oral argument thus far, and I therefore don't intend repeating paragraphs 60 to 66. Suffice it to say, in our respectful submission, the balance of convenience weighs heavily against her because of the total restriction of this critical feature of the NA's oversight powers. On the one hand, the public importance and public interest in the continuation of the Section 194 process on the same side of the scale, and her absence to point to any legally cognizable harm which she will suffer if the process continues and she were ultimately to succeed in the Part B relief. Against that backdrop, my Lord, I'm going to move on to page 39 then, the question of is PADGA applicable. In paragraph 67, we itemize the 5 grounds based on what are referred to in her heads of argument, her counsel heads of argument, as fairness and all the rules of natural justice, namely audi alteram partem and nemo judex in sua causa, as well as procedural irrationality. Well, with respect to my learned friends, I haven't seen a better job of hedging your bets than that in a while. The question is, as we raise in paragraph 68 and 69 on page 40 is the following. Are the applicants right in submitting in paragraph 82 of their heads of argument that these grounds of challenge, which they deal with under the heading fairness, can be borrowed, as they put it, from section 33 of the Constitution, which is the right to lawful, reasonable and procedurally fair administrative action, in 33.1, and the right to reasons in 33.2, because they contend it's permissible to do so. This is the implication in what's essentially a rationality review. My Lord, may I ask you if you are still with me? I've lost your picture, but I do see a VS.
He's just stepped out for a second. Had a bit of a crisis. He'll be back in a second.
May I continue, Justice Steyn, or would you prefer me to wait?
I think you may proceed since it is being recorded.
Thank you, Justice Steyn. I shall do so. Thank you.
Thank you. Thank you, Ms. Bredenbach.
So we submit in response to the attempt to borrow from the right to administrative justice in what the applicants concede is essentially a rationality review, that section 33 of the Constitution does not find direct application in proceedings for judicial review of administrative action, because following the enactment of PADGA, in terms of section 33.3 to give effect to the rights in section 33.1 and 2 that occurred in 1999 with effect from a date in 2000, all proceedings for judicial review must be brought in terms of PADGA. We refer here to Batterstar Fishing, well-known statement to that effect at paragraphs 21 to 26, which was the first decision to give explicit recognition to what's now known as the doctrine of subsidiarity. And that point was made by Cameron J. for the minority in the My Vote Counts case at paragraph 53 in note 100. But it was subsequently approved by the Constitutional Court in Public Servants Association 2018 2 SA 365CC at paragraph 25. So our first response then to this attempt to import the requirements of the right to lawful, reasonable and procedurally fair administrative action and the right to reasons in section 33 into what the applicants admit is essentially a rationality review, is that one cannot have regard directly to the Constitution any longer. After PADGA was enacted, you have to have regard to PADGA. And the question which then arises is whether PADGA applies. And we specifically referring here, obviously, to the rights to procedurally fair administrative action in section 3 and 4 and the provision regulating the right to written reasons for administrative action in section 5. And we submit that does not apply either to the making or to the implementation of the new rules by the National Assembly. We've dealt with this issue in our heads of argument at paragraphs 147 to 149. And at page 41 of the note, we summarize the argument. Essentially, as appears from paragraph 72, it's this. If one reads together, as you have to, the definitions of administrative action and decision in PADGA, because PADGA opens by saying administrative action means any decision taken, etc., by, and decision is defined as meaning a decision of administrative nature made, etc. What one has is, as was pointed out in a well-known passage in Gray's Marine Hout Bay, it's been cited with approval many times before, it's at page 526 of the bundle, paragraph 24, is the conduct of the bureaucracy, whoever the bureaucratic functionary might be, in carrying out the daily functions of the state, which involves the application of policy, usually after its translation into law, with direct and immediate consequences for individuals or groups of individuals. Now, we submit that neither the making nor the implementation of the new rules by the NA entailed or will entail the bureaucratic carrying out of the daily functions of the state. This is a highly unusual procedure. It is created.
Mr. Breitenbach, we seem to be losing your voice. Is that a problem experienced by others?
Not at our end, my lord.
Is that
No, Your Lordship.
is the other council experiencing the same problem?
No,
No,
we
Your
can
Lordship.
still hear him, my lord, clearly.
Okay.
My lord, would you like me to repeat
Clearly,
what I
it's on
said?
our side. Please hold for a second. We're just having the IT person just attend to this. Still. Can we move aside here? Mr. Breitenbach, you want to continue, and we'll see if our route is thank you.
I was submitting with reference to paragraph 40, page 41, paragraph 72 and 73 of the heads of argument, that the touchstone for administrative action is decisions of an administrative nature, that is the conduct of the bureaucracy, whoever the bureaucratic functionary might be, in carrying out the daily functions of the state. And the submission is that neither the making nor the implementation of the new rules by the National Assembly entailed or will entail the bureaucratic carrying out of the daily functions of the state. It is a highly unusual and specialized procedure of holding to account to the legislative arm a Chapter 9 office bearer, not daily bureaucratic functioning. There's a further reason, and that is that the definition of administrative action, as the court will know, has certain express exclusions, one of which in DD is the legislative functions of Parliament. And our submission is that as regards the making of the new rules, that is certainly a legislative function, and it is excluded from the definition of PAGA administrative action. So what we submit, therefore, is that there's no legally applicable or free-floating standard of fairness in this case. The applicable standard is rationality, substantive rationality, to which I've referred earlier, which is instrumental. In other words, that what you do must be rationally related to a legitimate government purpose. And it's in that context I made the submission about the court not having the authority to second guess the decision maker and say that something's irrational because there is another way of doing things, which in the opinion of the court is a better way of doing things. But it also has a procedural dimension, which we acknowledge. The cases in question are cited in our heads of argument at page 66, footnote 34, on substantive rationality and on procedural rationality. The Procedural rationality cases, the leading cases, are quoted in footnote 136. They are the Albert case and VA and the President, and then the Law Society of South Africa and the President. The references are all given. My learned friend referred to the components of procedural fairness, which is obviously a requirement for valid administrative action. And it has to do with affording a party likely to be disadvantaged by the outcome of proceedings a fair opportunity to be heard. It's encapsulated by the maxims audi alteram partem and nemo judex in sua causa. And its specifics are now encapsulated. I'm referring to paragraph 77.1 at the bottom of the page, to sections 3 and 4 of Hajj. May I ask the court to add and section 6.1c? So it's 3 and 4 and section 6.1c of Hajj. Procedural rationality is a more complex concept. And with reference to the cases, at 77.2 of the note, this is explained in our heads of argument, also in paragraph 149 and in footnote 136. What that entails is looking at the process as a whole and determining whether the steps in the process are rationally related to the end sought to be achieved. And if not, whether the absence of a connection between a particular step as part of the means is so unrelated to the end as to taint the whole process with irrationality. Now, in a particular case, that step might be giving someone a hearing, as we shall see in a moment with reference to Albert's case. But if you want to restate the standard or understand it in a different way, in its procedural sense, rationality requires that during the decision-making process, all material relevant to achieving the purpose be considered, unless ignoring it is rationally related to achieving the purpose or doesn't color the entire process with irrationality. Now, in Albert's case, it was found that it was irrational to give pardons to people under section 84(2)J of the Constitution without giving the victims' families or the victims themselves an opportunity to be heard in the process. And the reason was that this was an outflow of the TRC amnesty process, and its aim was national reconciliation. So the participation of the victims and their families was crucial to the achievement of that objective. And it was also held to be essential to determine the facts on which the pardons were based. And so a decision to exclude the victims from participating was found to be irrational. In the present case, as I indicated, my Lord, we accept that the participation of Advocate Mkhwebane in the Section 194 process is necessary. And the reason for that is that otherwise it will not be able to fulfill its function as the Constitution's ultimate accountability enhancing mechanism for her and the other Chapter 9 office bearers who may also be charged. But there's no question of her being excluded in this case, and consequently of the process being procedurally irrational. As I've already indicated, she has two opportunities to answer the charges before her, before the independent panel, and then obviously before the Section 194 committee.
Sorry, Mr. Brainbar.
Yes, Justice Amena.
Yes, there is still a problem. Could you please hold on for us, please?
Will
still
do,
a technical problem.
Certainly.
All right. Okay, thank you.
Okay. This is waiting in the knowledge. Mr. Breitenbach, we
Thank you, my lord.
thank you.
Thank you.
Yes.
I was-
Yes. Mr. Breitenbach, can you hear the court?
I can hear you somewhat unclearly, but I can certainly hear you.
Okay. Please proceed, and let's just see if we've sorted out this text. We might have a problem again, but please proceed.
Thank you, my lord. I was on page 42 of the note, and I dealt with what procedural rationality entails. I explained why Albert's case was one of those cases where there was an overlap between procedural rationality and procedural fairness. In other words, hearing someone who may be adversely affected is a requirement for a rational decision. I had said that in the present case, we accept that Advocate Mkhwebani's participation in the Section 194 process is necessary for it to fulfill its function as the Constitution's ultimate accountability enhancing mechanism for her and other Chapter 9 office bearers. And I just made the point made earlier today that there's no question here of her being excluded and consequently of the process being procedurally irrational. I referred in this regard to her right to make representations to the independent panel. In other words, a reasonable opportunity to respond to all the relevant allegations against her, and of course, her right to participate in the proceedings of the independent committee if the matter proceeds that far. It provides specifically, and I'm referring to Rule 129, capital AD, sub 2 and 3, not only that the procedure must be procedurally fair, but also that she has the right to be heard in her own defence. Your Lordship and I have already discussed the issue of her being assisted by a legal practitioner, but not having that practitioner not having the right to participate in the committee. The court knows that the applicant relies on the NERSA case, National Energy Regulator of South Africa. It's in our bundle at page 899. We submit that is misplaced. The issue under consideration there was the failure to take into account a relevant factor that ought to be central to a finding a rational or reasonable final outcome. It, in other words, was essentially a rationality case and didn't have to do with the RD rule in a multi-stage process. But in any case, in two of these stages, the screening stage and the actual committee stage, she is given a right to a hearing. And we would emphasize that, broadly speaking, there are these two stages before the political question arises. And that is at the end of after Section 194 1B. Screening, she can participate. In the actual inquiry, she can participate. And we consequently submit that there is no unfairness in this process. When the matter comes before the House, it is obviously a matter for the House. And what is interesting to me is that there is no contention, and rightly so, that she should somehow be entitled to address the full House as well. So we consequently submit that the whole starting point where submissions are made based on procedural fairness as distinct from procedural irrationality, and the reliance on pre and post PADGA administrative law cases about procedural fairness, not opposite, and it fundamentally undermines pretty much half of the grounds on which she contends these rules are constitutionally bad. That then brings me to her grounds of challenge. We're not going to deal with all of them. The court knows that in our heads of argument at paras 147 to 218, we deal with each of the 10 grounds, with reference obviously to the affidavits. What I intend doing today is to just state the gist of each point, and having done so, to refer to the relevant part of the heads of argument, and where necessary also to the parts of the papers not referenced in the argument, or to passages in the Speaker's affidavit cited in our heads of argument. My Lord, it is just after 20 to 2, and I promised to finish by 1:45.
Yes.
And I'm happy to stop if your Lordship wishes me to do so. I will.
How long would you need to take us through the remaining parts of this?
I will be finished by 3 o'clock, and I intend doing so by giving you references rather than arguing everything, because
Yes, okay.
if that's all right with your Lordship.
3 o'clock then, good.
So we have alleged mala fides on the part of the Speaker. It was submitted yesterday. The Speaker's attitude leaves a lot to be desired and evidences mala fides on her part. And in support of this submission, we understood our learned friend to advance 4 propositions. Firstly, the Speaker refused to agree to the suspension of the Section 194 process pending the final outcome of the application for the Part B relief. Now, in response, we submit the Speaker's refusal to agree to the interim interdict Advocate Mkhwebane is seeking, or to give an undertaking not to proceed with the Section 194 process pending the final determination of Part B, is explained on the papers. It is reasonable, and it is not indicative of mala fides on her part. In essence, the explanation is the Speaker believes the process thus far and the new rules in terms of which it is being conducted are lawful and constitutional, and hence there is no valid reason for the process to be suspended. She has a legal duty to process Ms. Mazzoni's motions in accordance with the rules, and that is all that she is seeking to do. And we give in paragraph 87.3 the annexes to her affidavit from which her most relevant actions appear. And I would wish to refer you simply to 2 documents in that list for now. May I ask you to turn, it's in volume 5 as I recall. Let me just check that. It's at page 502. Yes, it's at the start of volume 6. I apologize. To annexure TRM 46.
In repeating those, but there are a few aspects of it, isn't it?
502 to 503.
That would need to deal with. One relates to the.
Now this is the first letter.
First relates to the submission that P3 is
This is the first letter written by the Speaker after she was taxed by Advocate Mkhwebane about this process which has started. So this is a letter signed by her. She says there, and I quote, Parliament is by way of legislation as well as the rules, including those which give effect to Section 194, met its constitutional obligations, specifically those imposed by Section 181. Together with Section 101, the Constitution simultaneously provides for the removal of such office bearers as the Public Protector. To this end, the Constitutional Court certified that Section 194 serves as a mechanism with which to ensure the effective execution at the required standard of care of the duties associated with such independence. Section 181 required independence cannot be read as excluding the operation of 194. I therefore confirm that the substantive motion complied with the form requirements in the rules. No decision has been made as to the required prima facie assessment, as the independent panel is yet to be established, after which panel members must conduct and finalise a preliminary assessment, including an invitation to the holder of the public office to comment on the substance of the motion. And the National Assembly and joint rules safeguard against any risk of abuse of that power or unfairness, including the inquiry process outlined in the new rules. Parliament's processes and the new rules adhere to the rules of natural justice, including alteram partem, and are informed by the relevant constitutional principles of fairness, transparency, and accountability. There is accordingly at present no reason to suspend the implementation of the new rules. Well, what then followed was a backwards and forwards of correspondence, and I wish simply to confirm or refer the court to the last letter in the relevant series, which is TRM 69. It's a long letter. It starts at page 577 in the same volume. And it followed the replacement of Ms. Mazzoni's motion and the Ms. Mkhwebane being notified by the Speaker of that on the 26th of February. So then that letter remonstrating about that was received from Advocate Mkhwebane's attorney, And that letter concludes with the following at page 583, paragraph 18. Finally, we are instructed to inform you, as we hereby do. This is now the State Attorney speaking on behalf of the Speaker, that our client remains of the view that there is no basis either in fact or law for your client's urging that our client undertake to suspend the processing of the new motion. On the contrary, Section 194 of the Constitution and the rules of the National Assembly together require that the process started by Ms. Mazzoni's motion of 21 February 2020 continue. So what we're dealing with here is essentially with a public officer, the Speaker, doing her job. And it's distressing to read in the, particularly the replying affidavit of Advocate Mkhwebane, and to hear submissions from my learned friend yesterday that is somehow evidence of mala fides on her part. It's a matter of concern that a person occupying as high office as the public protector does should see fit on the basis of such flimsy evidence to level a serious allegation such as this against a high office bearer, the Speaker of Parliament. The second basis is the Speaker issued media statements about her acceptance of Ms. Mazzoni's motions without first informing Advocate Mkhwebane of her decision. Now, in this regard, we submit the following. While it's correct that on the 25th of January this year, the Speaker issued a media statement about her acceptance of the first motion without first informing Advocate Mkhwebane, we submit there's nothing untoward about that. And in our heads at paragraph 199, we give the Speaker's main reasons for doing so. It's on page 97, the last few lines on the page. May I read them to the court? The main reasons the Speaker, and this is done referenced with reference to her affidavit. The main reasons the Speaker made a public announcement at that juncture were: A, the commencement of the process aimed at the establishment of the independent panel was the first public step by the National Assembly in relation to a matter of public concern. B, the sending of the Speaker's memorandum to the political parties, that was the one calling from them to nominate people for serving on the panel, meant it was bound to receive some publicity. And C, the Speaker wanted to ensure that the media was able to report accurately on what was happening. Those are the facts, and they negative any inference of mala fides which is sought to be drawn on this basis. As regards the acceptance of the second motion on the 26th of February, there is no question there of Advocate Mkhwebane finding out from the media. On the same day, as explained in our heads at paragraphs 116 to 119, that the Speaker accepted the motion was in order, she informed Advocate Mkhwebane of her decision and of the next steps. They are set out in the relevant correspondence, and that is Annexure TRM 67 at pages 564 to 568. Then there is a contention that this, and this was quoting my learned friend, has taken up the cudgels on behalf of the DA by defending the actions of the DA members who submitted the motions for Advocate Mkhwebane's removal from office and who criticised her in meetings of the Justice Portfolio Committee. It's simply not true that the Speaker has taken up the cause of the DA. What she has done is she has come to the defence of Parliament as an institution. It is comprised of people. Some people are members of her party, the African National Congress. Others are members of other parties, including the DA. What she did in her answering papers, and we refer to this firstly in paragraph 195 on page 95, is explain why, when submitting the motions for Advocate Mkhwebane's removal in terms of section 194, Mr. Steenhuisen and Ms. Mazzoni, both of whom acted as they did in their capacity as the chief whip of the official opposition, were exercising rather than abusing a right conferred by the Constitution. And secondly, what she explained, and this is dealt with in our heads at paragraphs 202 to 204, that when engaging with Advocate Mkhwebane in the Justice Portfolio Committee, and I just emphasize also that's the former Parliament's Justice Portfolio Committee under Dr. Motshekga in March 2018, the DA members of that committee, and indeed the members who belong to other parties, because if one reads the Parliamentary Monitoring Group report, the narrative of which is an accurate summary of what was said, these people were exercising their rights of freedom of speech under section 58(1)(a) of the Constitution in the process of seeking to hold the public protector accountable for the performance of her functions as such. In other words, in the performance of their power and duty under Section 181(5) of the Constitution. And again, it is distressing that the public protector should seek to mischaracterize what is obvious from the papers, which is the Speaker speaking on behalf of the National Assembly and defending its function. One sees a similar problem with her attacks on the Speaker and the Deputy Speaker. These are the former Speaker and Deputy Speaker, for joining the President as a co-applicant in the Bosasa case to have set aside the remedial action, which in their estimation, and as was found by the by the Gauteng court, impinged upon the power of Parliament to regulate its own process. We know, for instance, in the proceedings before Justice Murphy, right at the beginning of the CIEX saga, exactly the same thing happened. Parliament came to the senior office bearers of Parliament, the Speaker and the National Assembly, came to defence in legal proceedings of its duty to manage its own affairs, where someone, in this case the public protector, had gone too far. You'll recall that was the case where she instructed an amendment of the Constitution to change the mandate of the Reserve Bank and put the relevant portfolio committee on terms to report to her within 38 days on the progress it had made. The last contention of mala fides levelled against the Speaker concerns Ms. Mazzoni's withdrawal of her first motion and the submission of a new one on the 21st of February. Now, that's somehow said to evidence mala fides on the part of the Speaker. We fail to understand what evidential basis there is for this serious allegation. And again, it is distressing that such a senior official should bandy around allegations of bad faith based on a complete absence of evidence. The evidence is to be found in the Speaker's contemporaneous correspondence, confirmed in her affidavit, and I refer in particular to Annexure TRM 67, which is in Volume 6 at pages 564 to 568, and especially paragraphs 4 to 9 at page 565. And I shall read briefly to the court what they say. Ms. Mazzoni was entitled to withdraw a motion of 6 December when she did. Rule 128.1 of the Rules of the National Assembly provides a member who is given notice of a motion may withdraw it at any time before being called upon to move it in the House. By February 2020, Ms. Mazzoni had not been called upon to move her motion in the House. Having withdrawn her motion, Ms. Mazzoni was entitled to table a fresh one in terms of Rule 129R. The fact that your client had instituted the above-mentioned matter, this is the present case, was no bar to the withdrawal of the 6 December motion and the tabling of the new one. Upon Ms. Mazzoni having tabled the fresh motion, our client, that's the Speaker, was obliged to consider the new motion and decide whether it's in order. Our client has now duly considered the motion and decided it's indeed in order. Having reached that decision, our client has consequently restarted the process aimed at the establishment of the independent panel by notifying the political parties of Ms. Mazzoni's withdrawal and replacement of her motion and calling on them to nominate fresh persons for appointment. In the premises, your reference to patently unlawful and unauthorized conduct by our client is incorrect and is denied. Interestingly, in the letter which precipitated that response, there wasn't an allegation, as far as I can recall, of mala fides, yet my learned friend sees fit to make it yesterday. Frankly, out of order. There are cases, and I am not going to go there, but there are cases in South Africa and elsewhere in our neighbouring states where these kinds of unwarranted allegations of bad faith against public office bearers who are simply doing their job are visited by personal cost orders against the people making them. But we are not seeking that in this case. My client is at pains to point out one thing. She is acting in accordance with the rules. She is simply doing her duty here. But it is a matter of concern that someone in a senior position as the public protector should cast the aspersions that she has done against the Speaker. Then my learned friend alleged procedural unfairness, procedural irrationality in the rules. So just to contextualize this relates to Part B, and it goes to the challenge to the rules. It hasn't to do with the conduct of the Speaker. It It has to do with defects in the rules themselves. In other words, what his client's ultimately going to be contending in Part B in November. And these are itemized in paragraphs 92 to 96. There are 4 of them. Insofar as there's reliance on procedural unfairness, I've already submitted that that's not the touchstone. The first allegation is the rules don't oblige the Speaker to notify the public protector or any other Chapter 9 office bearer against whom a motion for a removal has been submitted of the submission of the motion and give her an opportunity to be heard before deciding whether it's in order. Now, our responses to that are essentially, firstly, that procedural rationality, which is the applicable standard, doesn't require that. Secondly, as we've explained in our heads of argument, and I've mentioned a few times before, she does have a chance to participate during the screening process before the independent panel. The second allegation in this connection is that the Speaker misconstrued her powers by saying that this motion was in order because she didn't investigate whether the evidence supporting it established prima facie a case and wrongly assessed solely whether the form of the motion was in order. Well, firstly, this of course is not a challenge to the new rules. It's a challenge to the Speaker's application of the rules. It would be a review ground. But there's no, the primary relief sought is, in this case, in Part B, is attacking the rules. Quite understandably, no decision having been taken adverse to Ms. Mkhwebane, there can be no judicial review of the process at this stage. And my learned friend would be, and his client would be getting ahead of themselves somewhat if they were to bring such an application at this stage. We deal with that in paragraph 93.1, and I've already dealt with in argument this morning the interplay between 129R1A and 129X1B, the references to prima facie there. The one has to do with the screening function of assessing the motion in its own terms, and the other has to do with assessing the evidence. The second reason relating solely to the rules is that it concerns reasons. Now, it's true that she doesn't have to give reasons for her decision, but we submit that there's no requirement of rationality that she give reasons. The Speaker, we deal with that in paras 167 to 169 of our heads of argument. Advocate Mkhwebane will have ample opportunity to herself to say whether the motion is in order or not. She can defend herself on any basis open to her, and ultimately whether it is or isn't is an objective question. Then there's the legal representation point in paragraph 795. I've already dealt with that this morning with your Lordship presiding. We simply point out that, as indicated at the bottom of page 49, the reliance on the rules of the judicial conduct tribunals under the JSC Act is inapposite, because the composition of the judicial conduct tribunals, 2 judges and a third person from a list kept by the minister, is very different from the composition of a Section 194 committee, politicians who are members of the National Assembly. And second, judges are not constitutionally accountable to the judicial conduct tribunals like Chapter 9 institutions office bearers are to the National Assembly. The last argument concerns the absence of safeguards against the involvement of people who may reasonably be suspected of bias. We know what her particular allocations in this case are. We deal with that in paragraph 96. In our heads, we deal with this aspect in relation to, firstly, the composition of the Section 194 committee. Secondly, the voting on the impeachment motion, where we contend everyone has to participate, subject obviously to clearing conflicts of interest. And thirdly, we would point out that there was some emphasis placed yesterday on the judgment of Zondo DCJ in the EFF impeachment case, paragraph 118 in this context, but that is a dissenting judgment and nothing similar is stated in the judgment of Jafta J for the majority. As regards the attacks on the new rules which are not related to procedural fairness, there's the retrospectivity point, which I've already dealt with. I refer to paragraph, again in paragraph 98. As far as the definition of attempt to rely on incapacity is concerned, I mentioned to your Lordship that the Giant Concerts case, which was sent to the court yesterday and to our opponents yesterday afternoon, is a further nail in the coffin of this argument. Not only is it one of the grounds in Ms. Mazzoni's motion, but as a consequence of that, Advocate Mkhwebane lacks personal standing to challenge the constitutionality of the rules in relation to the definition of incapacity. And the reason for that is it doesn't directly affect her rights or interests, or potential rights or interests, as they emerge on the facts of this case. It's not a big point, but I should just mention that. The second complaint concerns the appointment of a judge to the independent panel in violation of the separation of powers. And we deal with this in our heads at paragraphs 216 to 218. I would just like to take the court there just to give you a reference which is omitted from the head. So if you could turn to pages 108 and 109 of the heads of argument, please. So, my lords, the leading case is the one quoted in paragraph 255, the National Society for the Prevention of Cruelty to Animals case, which is in our bundle at page 922. And we've cited paragraphs 13 and 38. But we do submit that the whole case merits close reading, because what the Constitutional Court did in this relatively recent case was to survey its earlier jurisprudence, including the South African Association of Personal Injury Lawyers and Heath case, to which my learned friend referred, which is in the applicant's bundle. I don't think my learned friend, perhaps he did it it's in the applicant's bundle. But what I wish to do is at the end of para 218, the second last sentence, we explain why the performance or appointment of a judge is not constitutionally offensive in this particular matter. Yes, it's not a judicial job. It's a non-adjudicatory screening function focused on whether there's prima facie evidence to show that the holder of the office committed the alleged misconduct, incapacitated, or is incompetent. But it is compatible with the office of a judge, and it will not be harmful to the institutional central mission of the judiciary. And our reason for that is given in the following sentence. More specifically, the performance of the panel's functions calls for qualities and skills required for the performance of judicial functions, including independence, the weighing up of information, and the forming of an opinion based on information. And those were specifically found by the Constitutional Court in the Heath case, and I'd like you to note against that. So that's the Sarpel and Heath case. In the applicant's bundle, paragraph 34, page 133, and it's where it starts, and this particular paragraph's at page 142. So that is specific authority for the proposition in the second last sentence of that. There was then a contention that the new rules violate the public protector's right to fair labour practices. Now, we've dealt with that in our heads at paragraphs 156 to 159. Basically, the answer is the public protector is not employed by Parliament, the President, or anyone else. And if you have a look at pages 72 to 73 of our heads of argument, you will see in that regard that we refer in footnote 155 to the Minister of Home Affairs in the Public Protector case. There is unfortunately a typo in 155, which I'd ask you to correct. The cited paragraph number 17, it's at page 73. I apologize, that should be 37, where that statement is made, and it's in our bundle at page 805. There was a rather strange submissions were made yesterday. You'll recall my learned friend reading from provisions of the Public Protector Act, which referred to the Public Protector's terms and conditions of employment. Does your Lordship, presiding, recall that, or the other justices recall that?
Yes, that is a full discussion, yes.
The difficulty with that is that he was reading to you from the unamended version of the Act. Yesterday, we sent you the Act as amended by the by Act 22 of 2014 with effect from 1 April 2019, where none of the references to the terms and conditions of employment and other things indicating employment in the case of the public protector occur anymore. In the case of the Deputy Public Protector and her staff members, there are references to them, but they've been taken out of the Act. Not quite sure why my learned friend acting for the Public Protector didn't have a current copy of the Act, but there we have it. Then there was a contention that the rules violate Chapter 9 office bearers' rights of access to courts guaranteed in Section 34 of our Constitution. And we deal with that in our heads paragraph 155. And the simple point is that we are not dealing with provisions which are resolved by the application of law. This is ultimately a political question, and consequently it doesn't raise a dispute that can and should be resolved solely by the application of law, because there's this crucial political judgment at the end of the process. So we submit that the Section 34 right does not avail her.
Mr. Buitenbach, our early discussion, there is some application of law which is going to be required in the inquiry.
That is correct. But the requirement is that the dispute must be one which is, let me just read the wording of the right to the court. It goes to the resolution of the dispute, my lord. Everyone has the right to have any dispute that can be resolved by the application of law decided in a fair public hearing before a court, or where appropriate, another independent or impartial tribunal or forum. So what it means is that if the resolution of the so-called dispute, in this case there would be a dispute between Ms. Mazzoni and the public protector, can be resolved in that way, then it must go to court, or where appropriate, another independent and impartial tribunal and forum. But in the self-same Constitution, it is stated that this dispute is not resolved in that way. It is resolved by a vote of politicians in the National Assembly. And as I have already submitted, it's a precondition for that there be a finding under Section 1941B by the committee adverse to her. That is necessary but not sufficient. And despite that finding, it could be overwhelmingly defeated, or binarily defeated, but defeated. I'll leave it at that. Why? Because of the exercise of political judgment which the politicians there have to exercise. It's not necessarily partisan political, but it's politics, it's statecraft. It's not the job that someone like I am familiar with, looking at it from afar, which with respect is your job and fits within the Section 34 panoply. And so that's the point.
So why is there a need for a panel as proposed, which requires legal minds to assist in establishing whether there's prima facie evidence of a contravention of the provisions?
That goes back to the UDM case, and particularly the EFF impeachment case, where the Constitutional Court said there has to be a screening function. And what the National Assembly have decided essentially is that an advisory panel will be established, because that's what it is. It considers all of this, it makes a report, it makes recommendations, but the National Assembly has a right either to adopt or not to follow that. In other words, not to go forwards. So they've institutionally created a mechanism to screen out cases which call for an answer from cases which don't. And it's advice that is given. It's its prerogative to do that. The Constitutional Court has made quite clear that it can take such advice. So neither the independent panel nor the committee itself are impartial and independent tribunals or fora. This, in the self-same Constitution, you require a committee of politicians to deal with this, because it's essentially ultimately a question of exercising political control through Parliament, the legislative branch, over the functions of Chapter 9 institutions. It's a fine balance, but it's certainly not a Section 34 matter. Then there's the sub judice rule. My learned friend, for the ATM's point. You'll recall that there are two legs to this argument. The first is that there's a conflict between this rule and the sub judice rule, which is 89 of the National Assembly rules. And also it appeared that there was a contention that there is a conflict between what is now proposed and the requirement in section, I see there's typographical error in my note, page 52 in paragraph 102, third line. I refer to section 164.4. That should be 165.4. I apologize. My typewriter, I'll blame it on my typewriter rather than my fingers, is letting me down badly in this case. Now, that imposes an obligation on all organs of state of the to assist and protect the courts, ensuring the independence, impartiality, dignity, accessibility, and effectiveness. And the courts then go on to be dealt with in section 166. So the contention is that if motions concerning matters which are still form the subject matter of unconcluded proceedings in courts of law, there will be a conflict between the sub judice rule and with this requirement in the Constitution. This is dealt with in the main answering affidavit. Now, my Lord, this is off the heads. For some reason, this slipped through the cracks, so I'm referring to the two affidavits in question. The Speaker's main answering affidavit, paragraph 261, and a supplementary answering affidavit, paragraph 9. The page numbers are given. The sub judice rule and those sections of the Constitution we submit don't preclude members of the National Assembly from performing their oversight functions, or for that matter from initiating and participating in impeachment processes. And the reason is, if they were so precluded, and what would then happen whenever a case came up where a very serious charge was leveled against an incumbent, which happens to correspond with a matter on which a decision in a court of law is pending, for instance, a review of the Public Protector's report, the NA's power to remove the incumbent from office so long as the litigation is pending would be stultified. So let's assume, just for hypothetically, that the ground of review is that the Public Protector, let's depersonalize it, that a Chapter 9 institution, office bearer, took money it's a corruption case. And that is, they apply to have reviewed and set aside a particular act, instrument flowing from one of these Chapter 9 institutions. The Auditor General's been accused of taking money from someone or other to give a green light to a hopelessly corrupt municipality, to overlook corruption in that municipality. So they want to set aside that approval of the financial statements of that municipality under the Public Audit Act. But obviously, if that were the truth, and just to add spice to it, the Auditor General's been arrested on that charge, is in custody, bail denied, and is about to be tried. So there's also a criminal case which is pending, and none of these things, we're told, can be raised. This is how the argument goes in impeachment proceedings. You must put up with the incumbency of that person until these legal proceedings are concluded. But that just can't be right. These are important public institutions. They're there to perform a job. I'm not suggesting that we are dealing here with corruption. That mustn't be misunderstood. But what I am saying is that where a public representative properly raises a complaint of this kind, Parliament can't have its job stultified just because of the happenstance that there is litigation about it. In other words, the sub judice rule and these sections of the Constitution are subject or must be read together with the rights and duties of members in the National Assembly in terms of section 194 and the rules giving effect to it. My Lord, I don't intend to detain you at all on the question of the final interdict. Your Lordship's point to my learned friend yesterday that the persons concerned are not cited as respondents is dispositive of that. In any event, we've dealt at length in our heads of argument with the conflicts of interest complaints at paragraphs 245 to 249, and none of them come close to establishing the clear right, which is necessary for the interdicts which are being sought in this matter. And we deal generally with this, the absence of an alternative remedy. There's, of course, an alternative remedy. It's the same remedy which exists in this case. There can be a review of the decision if there's ultimately a decision. As far as the costs issues are concerned, very briefly, We understood the applicant to accept yesterday that the court will be condoning the late delivery of the Speaker's main answering affidavit. In line with paragraph 2 of the Speaker's notice of application for condonation, which is in notices at page 61, we submit and consequently pray that such costs be costs in the Part A application. I would emphasise, my Lord, that this application was brought on the 4th of February and the Speaker filed her answering affidavit less than a month later on the 3rd of March. My learned friend said something yesterday and also in his heads of argument to the effect that leave aside Republicains and Publicaties in their own timetable, answer by the 17th of February, which she had prescribed the Speaker was outside the DA's permitted by the rules of court. I'm not sure that that's correct at all. And your Lord has the court has the answering affidavit. It was a huge job that had to be undertaken involving the Speaker at the time of the State of the Nation address and the budget, plus the change in the motion on the 24th and the Speaker's having had to deal with it. I submit that all things considered, the cost of that, it was unavoidable, and the cost of that should simply get caught up in the wash, the cost of this application. As far as the costs, if my client is successful, what about let's start with the ATM and then deal with the public protector. As far as the ATM is concerned, that if the court refuses to grant this Part A relief, it should not order the ATM to pay the Speaker's costs. It's a similar issue arose in the EFF interim interdict case and is dealt with in paragraphs 83 to 85. The ATM is a private party. Yes, it's a political party. It participates in Parliament, but it itself is a private party. It's seemingly acting in the public interest. It's pursuing arguments of genuine constitutional concern, and it's consequently protected by the Biowatch principle. So we don't quibble with any of that. As far as Advocate Mqwebane is concerned, she is litigating in this case in her official capacity. Although it does really concern her in her private capacity, but there she is in her official capacity, the public protector. She does not, as we understand it, she isn't seeking to vindicate her own rights. She's seeking to do this on behalf of the office and the institution of which she forms a part. Consequently, she's not a private party and she's not protected in that capacity by the Biowatch principle, and therefore she should be ordered to pay the Speaker's costs in her official capacity, including the cost of 2 counsel should she fail with Part A. What, on the other hand, if the court is with the applicant here and decides to grant either the interim interdictory relief or the final interdict? Well, if the final interdicts are granted, then costs must follow the result. We accept that. That's paragraphs 3 and 4. If the interim interdict is granted, then we submit that one of the 2 conventional orders should be made, either that the costs of the Part A proceedings be costs in the Part B proceedings, or that they stand over for determination in those proceedings, because lots of water is going to flow under the bridge, and the court dealing with the final proceedings will be better placed to make an adjudication of costs. So my client therefore prays for an order refusing the relief sought in Part A of the notice of motion with costs, including the cost of 2 counsel, payable by the public protector in her official capacity. And I'm indebted to you for allowing me to run on, and to my learned friends for not interrupting me as I finished.
Well, Mr. Weidenbach, there's just one issue that still lingers with the court, and that is, at least with me, is the appointment of a judge to the independent panel.
Yes,
Given that there also appeared to have been some debate in the committee process as to whether it should be a retired judge or an active judge in service. Why was it not more desirable that it be a retired judge as opposed to a judge in active service, and whether that's desirable that it be a judge in active service as opposed to one retired?
So I suppose it falls into that category of things which could be, in the eyes of the court, better. For whatever reason,
Yes.
the decision was, and if you don't mind, I'm just going to turn to the specific provision. It's include a judge who may collectively possess the necessary legal and other competencies. So now, if it's a judge, well, I suppose the first submission is, what is meant by a judge? And in the I can never remember the name. It's the conditions. It's the Judges' Conditions and Remuneration, Conditions of Service and Remuneration Act. I'm sure the Lordship and the members of the court are better familiar with it than I. But there are these classes of judges, and depending on certain facts, even when one retires at 70, you may be liable to be called on, if necessary, by the head of the division or the Chief Justice. In some instances, you have the right to refuse, and in others, you don't. I don't have the details to hand. But you remain a judge for purposes of that act, and it could well be that the judge, as contemplated here, would include a retired judge. You heard yesterday that 2 retired judges had been nominated by one of the political parties. There is a safeguard here, and that is that, as Justice Steyn pointed out with respect, the judge must be appointed by the Speaker, but 129V says in consultation with the Chief Justice. And what that phrase means in our public law is with the agreement of the Chief Justice. So a judge cannot be appointed if the judiciary cannot afford to lose a member because they're stretched, or if the Chief Justice decides that it is not in the interests of the judiciary that a judge serve on this particular panel for whatever reason. So the Chief Justice, who is the head of the judiciary, is given effectively a veto right over the appointment of any judge, and will consequently be able to exercise that power should the service of a judge in a particular case either denude the judiciary of scarcely needed skills at that time, or be inappropriate, not fit with the functions of the judge, or whatever the reason may be. So we submit that there is an adequate protection for the judiciary in relation to that. I've been asked, my Lord, I've just received a message just to clarify one thing, and it goes to Advocate Nkwebani's opportunities to speak. At page 43, in paragraph 80 of the speaking note, I mentioned, as you'll recall, firstly, that she has the right in writing to address the independent panel, and secondly, she has the right to participate in the proceedings of the 194 committee. And I said that she has no right to speak in the National Assembly itself if the matter proceeds that far for a vote under section 194(1)(c), read with section 194(2)(a). That was my submission, and I added that I noted that there was no claim from the applicants that she should be given that right. I understand that someone listening to my address it came across that I might have said that she has a right at the third stage in the NA. That's not the legal position, and that's not our submission. And I apologize if there was any inconvenience caused there. Confusion.
No, we understood that should not have a right to address the National Assembly. Good. Judge Steyn, anything? Judge Mela, good. Thank you, Mr. Breitenbach.
Thank you.
Ms. Bauer, are you next?
I am, Your Lordship.
Thank you.
Your Lordship, I won't detain you very long. The President abides by the order of the court and has provided the court with written submissions. I don't intend repeating those submissions, but there's a few aspects that have arisen during the course of argument that I'd like to address. The first is the submission here that Pre-3 is academic because it is alternative relief and that the rules are so obviously unconstitutional. The second is the whole question of interim relief and the nature of the relief sought against the President. And the third is the reference to an acceptance that there's a tainted conflict of interest, and in the course of that I'll address you on the difference between bias and conflict of interest. So on the first submission in relation to Pre-3, it has not been expressly abandoned. So one must then assume that if this court does find that the rules are constitutional, then we understand that the applicant would want Pre-3. There is no argument made to this court in respect of Pre-3 specifically. You will recall just before the lunch.
I was told that it was academic.
That's the point, except that there were submissions made of conflict of interest and bias, which then got expressly located into the grounds of unfairness with reference to Pred 2. But then there was reliance placed on specifically paragraph 26 of the President's affidavit on page 678, which didn't deal with Pred 2 at all. So the submission is, on the one hand, it is academic, but there's a line of cases which goes back to the S. v. Jordan decision in the Constitutional Court. And one of the more recent ones is the Minister of Justice and another v. SA Restructuring and Insolvency. And essentially there, the citation is 2017-3 SA 95 at para 38. And it concluded, the SCA concluded that even though they've disposed of the matter, it may nonetheless be desirable, particularly when regard is had to the remedy sought by the respondents, for a view to be expressed on other relief sought as well. I take it now higher than that. If my learned friend comes back in the reply and he says they've abandoned Pred 3 expressly, then nothing further needs to be said by the court. The second submission relates to the application of the outer judgment. Mr. Mpofu pointed out that the relief sought is pending finalization of the relief in Part B, and hence the outer judgment didn't apply. Now, Mr. Breitenbach addressed you at length on that. The simple point to be made on that is essentially that there is nothing sought in respect of the President in Part B. It is for that reason that the interdict is not of an interim nature, but would be finally in effect vis-a-vis the President. So that's the one reason. The other reason is that the criteria used in the outer judgment, essentially, that you must carefully assess how and to what extent the relief sought would disrupt the executive or legislative functions. This is an executive function that is sought to be interdicted. And so our submission in that regard is that the interdict of power that the Constitution entrusts to the President outer would apply. And so the very strict requirements that Mr. Breitenbach emphasized would be of application with relation to the President. Thirdly,
when and if and when the President is called upon to suspend a person, would they have a right of audience or representation prior thereto, or is that entirely in the hands of the President?
Mr. Breitenbach made the submission to you that it's by its very nature administrative action, although he wasn't binding himself to it. Now, I had a look at these two provisions under section 194.3, A and B. B is where the President acts by rote to remove the person from office upon the adoption by the Assembly of the resolution calling upon that person's removal. Whatever audi is given then precedes the process before the National Assembly. So that's not the one that's applicable. Where the President suspends under section 194.3 AI, I must accept that there has got to be some form of audi prior to the suspension. That doesn't necessarily mean an oral hearing. It could very well mean that the President addresses correspondence or in some way says to the public protector, I have been asked to suspend you. These are the grounds upon which I was asked. I ask you to make submissions to me in relation thereto. And I would submit that that would probably but some form of audi of that nature would have to take place. The exact nature of that would lie with the President. So in this instance, the interdict is final in effect, but it's actually only relevant to the conflict of interest arising from the pending litigation between the President and the Public Protector. And Mr. Breitenbach addressed you on the proceedings before the North Gauteng High Court, and that matter is currently pending before the Constitutional Court to be heard on the 29th of September. Those proceedings are entirely unrelated to Part B. So, although the founding papers are unclear as to what the source of the alleged conflict of interest is in paragraph 123 of the applicant's heads of argument. They in terms clarify that it is only in respect of the ongoing Bosasa case litigation which created what they accepted to be was a potential conflict of interest on the part of the President, or a sufficient risk thereof in terms of 96(2)(b) of the Constitution. Now, one knows that within the structure of the Constitution itself, the Public Protector acts as a check on the conduct of other organs of state, including that of the President, and it contemplates that the Public Protector could make adverse findings against the President. Similarly, the President is called upon to exercise a constitutional power which affects the office of the Public Protector. So the Constitution envisages a contestation of views between organs of states and mechanisms to resolve it. The one cannot nullify the exercise of the other. So the fact alone that the Public Protector has made adverse findings against the President cannot on itself neutralize the President and act as an impediment to the President exercising a constitutional power that implicates the Public Protector forever and in all instances. What happens in this case, the President accepts that it would be inappropriate to exercise any constitutional power conferred on him in circumstances where there currently is a conflict between the exercise of such power and his private interest could arise. And what I mean by that is, he has accepted that whilst there's pending litigation, it could constitute a potential conflict of interest. Once those proceedings are complete and the court has ruled and it's fallen away, then there's nothing which precludes him from exercising it. So in his affidavit, he said to the court, as I'm permitted to do under the Constitution, whilst that case is pending, I will delegate that to another member of Cabinet to deal with, so that that potential conflict of interest which may arise if I'm asked by the National Assembly to suspend the Public Protector pending the outcome of the formal inquiry as contemplated in section 194(3) of the Constitution, then that would potentially fall away. And that's the high watermark of what the President says.
Ms. Bauer,
Yes, Your Lordship.
Ms. Bauer, can you hear me?
I can. You're a bit.
Can I raise with you other than
Sorry, Your Lordship. I'm losing you.
pending legal proceedings? Were a public
I'm
so I'm breaking up.
You're breaking up.
Can you hear me? Losing, can you hear? Hello?
I can hear you faintly, but there does seem to be a problem.
Hello, can you hear me?
I can hear you now, Your Lordship.
Faintly.
Yeah.
Okay, this route we're using seems to come and go in terms of its. Can you use
Can you hear me?
I can hear you now. No, that's very faint, Your Lordship.
Can you hear me, Ms. Bauer?
Shamela, you coming across clearer?
Okay, can you hear me now?
There is a bit of an echo, but I can hear you. I think it might be because another microphone is on.
Okay.
My mic is off.
Okay.
Judge Stein.
Bauer, can you hear me now?
I can, Your Lordship. I think I've lost you again.
Can you hear me?
Can you hear me?
Okay, let's. Can you hear us now? No?
Yes, Your Lordship.
Things
I
seems to
did.
be very, very delicate. Yeah, so we're going to try again. I had raised the issue about other than legal proceedings, where a public protector in a report makes trenchant findings against the executive, as has happened in the past. Would that constitute a conflict of interest in further proceedings under the Act, under the Constitution?
Our submission is that it wouldn't, Your Lordship. Let's test that. If the President had accepted those findings and not challenged them, acting according to whatever prescripts the public protector has set out, there would be no reasonable basis to conclude that the findings themselves constitute a conflict of interest and that the President couldn't exercise his powers under 194.3. Similarly, the same would apply if the President challenged those findings and was successful. Then there would be similarly no reasonable basis to conclude that there would exist a conflict of interest if he exercised his power, if the public protector exercised the power improperly and it was subject to review and set aside. So our submission is that there's no extant conflict of interest that arises. The constitutional scheme has a checks and balances that exists within that scheme, and the existence of findings in a report in itself wouldn't undermine the scheme within the Constitution. And of course, if the President exercised his power in an improper way, he would be subject to review. Similarly, as the public protector, if that power was exercised improperly, that would be subject to review.
Thank you. Good. Judge Sumela wants to say.
Hello, Mr. Baba, can you hear me?
I can, Judge Sumela.
Yes. Just concerning this suspended public protector by the President, is there any definite mechanism as how it's being done? For example, regarding legal representation, is she allowed to have a legal representation when the President has to suspend him? If yes, then what?
So there is a power that the President has under the Constitution. There's nothing there which provides for any form of legal representation. Your Lordship would have seen in the 17-step plan that is set out in the rules. One of those steps is essentially relating to a referral to the President for purposes of dealing with the suspension. But it's no different to when the Deputy National Director of Public Prosecutions is referred to the President for a suspension, or any other person who's in the employ. The President deals with that suspension in a manner which is fair and improper, but it doesn't necessarily either precludes a representation from a legal representative or specifically allows for it. If the President, let me give an example. If the President writes off and says, I'm considering your suspension, there's nothing which precludes the person concerned from responding via a legal representative. There's nothing in the Constitution which deals with it, and the National Assembly rules would not regulate how the President deals with the suspension.
Okay, thank you.
Thank you, Ms. Bauer.
I pointed out that the President had indicated that while there is litigation pending, as aforestated, the President would delegate those functions, and there's no dispute that he can do so and that he's entitled to do so. But what my learned colleague did was he looked at paragraph 38, in which there was a reference to tainted, and you'll see that on page 682 of the record. And that was misconceived as a concession that the President accepted that the role or his position was one of being tainted. And one has to look at paragraphs 35 to 38 in its context to see precisely what was intended by the President when that reference was made. And if you'll bear with me, I'll read it out to you quickly. From paragraph 35 onwards, it says, the scheme of the Constitution is such that if I find myself in a situation where I have a conflict of interest in relation to the possible exercise of a constitutional power, I may delegate the responsibility or the exercise of such power to another member of Cabinet. It is not clear from Pre 3 of the Public Protector's Notice of Motion whether the interim interdict sought by the Public Protector against me is meant to completely neutralize the exercise of powers under Section 194.3 of the Constitution, whether I will still be permitted to delegate the exercise to another member of Cabinet. And so what concerned the President is clear from paragraph 37. To the extent that the order sought will completely prevent the exercise of the power under Section 194.3 by any member of the Cabinet, I submit that it is overbroad and as a result neither competent nor appropriate. So what this can't do is preclude the delegation to another member of Cabinet, and I don't understand the applicants to be saying that either. And then in paragraph 38, the point is made, to the extent that the delegation would still be permissible, then it must be made clear that the order operates against the President personally and will not affect his authority to delegate the exercise of the power under Section 194.3 of the Constitution to another member of Cabinet who is not tainted by a similar conflict of interest as the court will determine exists in relation to my pending litigation. And I submit that does not amount to a concession by the President that he is tainted in any way. The high watermark remains one of a potential conflict of interest arising because of the existence of litigation that is pending, one that would be over once the litigation is finished. Now, the submission was made that that the conflict of interest is tantamount to a reasonable apprehension of bias. And we submit that there is a distinction between a bias and a conflict of interest, and it's not used interchangeably. So maybe to test it in common English, one would say a conflict of interest is one where one's interest or obligation and another interest or obligation or duty converges in the same decision-making context. And so it typically arises where you are either asked to give up one of your conflicting roles in that. That is independent of any inappropriateness or bias. And a good example to demonstrate this by is there's a code of conduct for judges which address the question of recusal. And Article 13 of the recusal provision says a judge must recuse him or herself from a case, firstly, if there's a real or reasonable perceived conflict of interest, and secondly, where there's a reasonable suspicion of bias based on objective facts. And this is a clear indication that there's a clear distinction between bias and conflict of interest. And your Lordship would be aware that the law of recusal is premised on an objective test. It's not a subjective understanding of a reasonable suspicion of bias. If you wish to rely on facts or infer bias, you must show that a reasonable, objective, and informed person would, on the correct facts, reasonably apprehend bias. And we submit that that's not always the case with a conflict of interest, and is certainly not so in the instant case. Finally, Your Lordship, the applicants allege that there are certain steps which the President should be precluded from of the 17 steps earmarked by the National Assembly. And you will see that proposition is made in paragraph 1 23, page 33 of the heads of argument. And they highlight that this relates to steps 5, 6, 8, 9, 5, 6, 8, 9, 13, 16, and 17. I'm not going to take your lordships through it, but there's nothing there in those steps other than the speaker being told to inform the president of a referral, or the speaker recommending to the president, or the speaker informing the president that there's a request for a suspension. There's nothing there which requires any active participation of the president beyond what could be sought from him under 194.3. And so we submit that there's no merit or credence to that submission. And those are essentially the submissions. The president is not seeking costs against the public protector, and we submit that in light of the position adopted by the president, a cost order against the president would be inappropriate.
Ms. Bauer, does the position of the president require a specific order by this court, or is that simply to be accepted on the basis of the president having given a notice to abide and provided an explanatory affidavit?
We abiding and we're providing an explanatory affidavit, and to the extent that we've sought to assist the court in the context of the position of the president, that's all that we seek to do.
But in the light of the position adopted by the president, he at this point in time will be involved that he himself will not participate and that function will be delegated. Is an order required of this court to give effect to that undertaking by the president?
We submit not, Your Lordship.
Okay. Why not?
Because it's not necessary. Why would you need to do that? The relief being sought from this court under Pre 3 is essentially to interdict, pending the final outcome of the main relief, which is under Pre B, which has got nothing to do with the president. They're asking you to interdict those respondents or their members who have a conflict of interest from voting or participating in any way of the processes. The president is
assuming all of this process runs its course before there's finality in Part B.
Then it becomes academic. So let's assume the Constitutional Court hearing is completed. Then the issue becomes entirely academic in the sense that there's that potential conflict of interest is removed. Then there's no point served by your court order at all.
Thank you. Judge Steyn, just a minute. Good. Thank you, Ms. Bauer.
And maybe, Your Lordship, I should add what the president has done is he's accepted his constitutional obligations and his position, and one wouldn't seek to make a court order against him to do that which he's precisely indicated he would do. I'm indebted to you.
Thank you. Mr. Butlander.
Thank you very much, Judge Saldana. Judge Saldana, I've been having some slight connection difficulties over the past few minutes, but I'm hoping it won't detain us. If you do have any difficulty, please let me know, and if needs be, I will turn off my camera to assist with the bandwidth, but hopefully we won't have any difficulty.
Good. We can hear you clearly now for the moment.
Thank you. Long may it continue. Judge Saldana and judges of the court, we have listened very carefully to the address of our learned friends, Mr. Breitenbach in particular and Ms. Bauer, and we do not intend to repeat what's already been stated. We intend, we make common cause with many of the submissions that have been advanced, and we submit that the case brought by the public protector is entirely without merit and that it falls to be dismissed. In the course of this address, we propose to focus on 5 discrete issues, which we submit would be helpful to the court in dismissing the application, and the 5 are as follows. The first is the key flaws in the public protector's approach in this application. The second is the public protector's vendetta complaint. The third is the conflict of interest issue raised in relation to members of parliament. The fourth is one or two of the grounds of the merits attack on the rules. And then fifthly, the question of costs. Could I begin with the first issue, if I may? And really what this case has presented and the way it has been presented to you, we submit has been fatally flawed. Because what you were, and there were two fatal flaws. The first is that you were presented with an argument yesterday by our learned friend, Mr. Mpofu, which concentrated almost entirely on his merits attack in respect of Part B. In other words, he spent almost the entirety of his address dealing with what he contended were the flaws in the rules and why they were flawed as a matter of merit. But with respect, that doesn't get him out of the starting blocks, because what we know from the cases is that having prospects of success in Part B is necessary, but it is not sufficient in order to obtain an interim interdict. And the focus in interim interdict proceedings, whether under Setlogelo or whether under Outer, the focus lies elsewhere. The focus is on the three remaining requirements. That is, the showing of irreparable harm, a reasonable apprehension of irreparable harm, a showing that the balance of convenience favors the granting of an interdict, and the showing that there is no alternative remedy. And it is on those three issues that we submit with great respect our learned friend has not even begun to make out a case. So even if you were to assume in his favor that the grounds of attack in respect of the rules in Part B were good, and I'm going to demonstrate that they're not good, but even if you were to assume that those grounds were good, his client would still not be entitled to an interim interdict because he has failed to satisfy those three key requirements. And you see that, judges, from the Outer case, because in the Outer case, what the court did was it did not even look at the merits, the prospects of success. It said, for present purposes, we are not going to touch the prospects of success because the matter is pending in Part B. And nevertheless, it held that there had been a blatant failure to make out a case for an interim interdict. And we submit that that is exactly the position that is the case here. Now we're alive, of course, to the arguments that our learned friend Mr. Breitenbach advances correctly, which says that in subsequent cases you talk about that the court can have a peek at the merits and the court can have a peek at Part B. But with respect, this is one of those cases where it's not even necessary. And the reason it's not even necessary is because even if the prospects of success were good under Part B, there has been no showing whatsoever about irreparable harm. There has been no showing about the balance of convenience, and there has been no showing on the alternative remedy. And I'm not going to repeat the points that have already been advanced by our learned friend Mr. Breitenbach on that score, but we would simply emphasize that those are sufficient for deciding the case. Indeed, we would say in our respectful submission that this isn't even a case that passes the Setlogelo test. In other words, even if this were an interim interdict preventing someone from demolishing a structure or an interim interdict preventing someone from disposing of a car, these sorts of the failure to show irreparable harm, balance of convenience, and alternative remedy means that the argument cannot succeed. But of course, this is not a Setlogelo test. This is an Outer test. And it is an Outer test where the separation of powers is at its most acute. This is not merely a decision of some liquor licensing official or a tender official that is being interdicted. This is a process which is ongoing in Parliament about the potential removal of a Chapter 9 institution. It is quintessentially a matter that raises the separation of powers concerns for the reasons articulated, both in relation to the making of the rules, but also in relation to the actual impeachment proceedings. And so Outer says one needs the clearest of cases. That quintessentially applies here, and we are nowhere near that with respect. As I say, we don't even have an ordinary case made out for an interim interdict in this case, never mind the clearest of cases. So we submit that with great respect, the focus of the public protector has been on the wrong elements, and it has not begun to satisfy the requirements for an interim interdict. The second flaw, judges, that we would draw to the court's attention is the failure to appreciate that even if the rules were problematic in one or more respects, that doesn't mean that the rules are bad as a whole, and it doesn't mean that an interim interdict is justified. And let me give you two examples, and I'll come back to them. Let me assume, against myself, because I'm going to come back to the point, let me assume that there is a problem with the idea that a judge sits on the panel. And again, I'm going to demonstrate that there is no problem. That doesn't give rise to an interdict against the use of the proceedings in terms of these rules, because we do not know yet whether a judge will be appointed. And the concern, if there was one, would only arise if and when a judge were appointed. Similarly, the point about retrospectivity. If there was a concern that the rules are too broad because they allow for the removal for temporary incapacity, that would be a basis to interdict proceedings about temporary incapacity. But it's not a basis to strike down the rules as a whole in Part B, or to declare that the rules as a whole are not retrospective, or to interdict these entire proceedings. The public protector must...
Mr. Butler, with the whole debate around temporary incapacity, when a court sits in Part B,
yes,
a court would be entitled to sever certain parts of the rules in its discretion, or when it finds that any part is in conflict with the Constitution.
With respect, Your Lordship has exactly the point that I'm making. Section 172(1)(a) of the Constitution says that a court must declare law or conduct that is inconsistent with the Constitution invalid to the extent of its inconsistency. And the Constitutional Court has repeatedly said that what that requires is an approach of severance, which means that you preserve as much of the good as you can, and you only strike out the bad. So your Lordship has the point with respect. But it goes now to the question of an interim interdict. Can you interdict proceedings based on rules which, at best for the applicant, have problems which might not even arise in this case? Some of them we know don't arise in this case, like the incapacity question, because no one's contended for incapacity. Some might not arise in the case, like, for example, the judge. And we say that with respect, it just shows that there is no showing of a reasonable fear of irreparable harm, because we don't even know if these purportedly problematic provisions, and again, I'm going to explain that they're not, but these purportedly problematic provisions will even have any effect in relation to the present impeachment proceedings, which are sought to be interdicted. And that is what we say is the second flaw. It is an approach that it is an approach which almost appeared to be, if we can find one flaw in the rules, then the rules themselves are invalid, and that means the process must stop. With respect, that is not correct as a matter of constitutional remedy, and it is not correct at the level of interim interdict law. So that is our first submission. It is that the applicant's approach is fatally flawed in those two key respects. One, a focus on the merits to the exclusion of the other three requirements for an interim interdict, and two, a failure to appreciate that many of the flaws contended for could be cured by means of severance or a narrow remedy, and that many of those flaws might not even arise at all if such flaws even existed. Could I then move to the second point, if I may? And the second point we make relates to the vendetta, because our learned friend and his client have spent some time trying to portray that my client, the Democratic Alliance, and Ms. Mazzoni are on a vendetta against the public protector. But with respect, as the questions put by the learned judge presiding demonstrated, if anything, in fact, all my clients have sought to do is exercise their rights in terms of the Constitution, and indeed arguably their responsibilities. Because if they have a genuine concern that the public protector it does not comply with the requirements on the basis of her conduct in office, then they have a responsibility to raise that. But could I just demonstrate why that is so on the facts? Because with respect, allegations about vendettas and bad motives and bad faith are very serious, and they must be looked at on the facts, not on the basis of supposition and not on the basis of broad allegations. And the focus, it seemed, was that the vendetta the vendetta arose from the fact that my clients, or some of my clients, didn't contend that Ms. Mkhwebane should have been appointed to start with. Well, that much is public knowledge and doesn't produce any inference of a vendetta. And that there's an ongoing dispute about certain things that were said in that process. Well, again, that doesn't produce a vendetta. And I would make the point that those allegations about spies are pending in the courts and that the matter hasn't concluded. But the real focus of the vendetta was said to be that my client, the Democratic Alliance, and then Parliament had adopted a set of rules designed to oust Ms. Mkhwebane. That was the Sobukwe Clause argument. Now, the learned judge presiding already put a number of points to my learned friend on that, but I want to go back a stage just for a moment and demonstrate the facts. Because what this court will know from reading the papers is that my clients have been remarkably consistent on one thing. They have contended that Ms. Mkhwebane's conduct in relation to the Saab case, the Reserve Bank case, was of such a nature that it justified her removal. They said so as long ago as 13 September 2017, Mr. Steenhuisen's first request, and the court will find that referred to in the Speaker's answering affidavit at page 193, paragraph 25, where Mr. Steenhuisen raised a request for removal proceedings based on Judge Murphy's judgment, the very first judgment in the Saab case. But for reasons explained in the Speaker's affidavit, the proceedings did not take off. And of course, that focus on the Reserve Bank case remains the primary charge or the first charge against Ms. Mkhwebane. But what happened then was it culminated on the 5th of July 2019 in the public protector writing to the National Assembly and complaining about various aspects of the request for an impeachment. And the court will find that it is Annexure TRM 24 in volume 5, page 414.
Is that the letter of the 7th of July 2018?
Yes, I have it as marked as the 5th of July, but I'm sure that you've got it correct.
That must be the 5th, yeah.
It's the 5th of July.
Because it's coincidental, the same 5th of July 2019 with an equally long letter.
Okay, I see. So on that day, there is a long letter, and it says it makes various complaints about my client raising these concerns. And I draw attention to two aspects because they're relevant to what follows. The first is a lengthy complaint about the fact that my client has raised concerns about the Reserve Bank matter when it is still pending. And you will see that in paragraphs 18 to 23. Now, if I could just ask the court to make a note, of course, we know that that matter is no longer pending, and it was no longer pending by the time of the present impeachment charge being laid. So that's the first complaint. But it's the second complaint which is of more moment for the vendetta point, and that is the complaint at paragraphs 40 to 45. Because at 40 to 45, the public protector says you cannot initiate removal proceedings without rules, and she relies on the EFF2 judgment. So it is her contention that rules have to be in place before she can be removed. That then produces, on the 27th of August 2019, a letter from the Portfolio Committee, and the court will see that at TRM 28, which is at page 431 of the papers. That is the memorandum from the chairperson of the Portfolio Committee on Justice to the Speaker. And it says that the Speaker has received a letter from Mr. Steenhuisen about the removal proceedings in relation to the public protector. And then at the foot of the page, this is the important paragraph, the committee discussed the matter on 27 August 2019. The committee noted the absence of the rules on the removal of office bearers of institutions supporting democracy. The committee is of the view that it is important to have rules in place to ensure uniformity in the manner in which similar issues are dealt with and fairness in the relevant parliamentary parliamentary processes. And then over the page that the committee appreciates the need for this to be done urgently. So it is the Committee of Parliament that says we need rules, and of course they do so off the back of Ms. Mkhwebane's complaint. and the rules must ensure fairness for the removal of office bearers of institutions supporting democracy, i.e. Chapter 9 institutions. Not rules for Ms. Mkhwebane, but rules for these institutions. That then prompts the letter, which is the next letter in the papers, which is at page 433, which is a few days later, where Mr. Steenhuisen writes to the Speaker and says, refers to the matter, refers to the proceedings of the Portfolio Committee on 27 August, which is the one I've referred to, and says, kindly find attached here to a set of draft rules which the DA has drawn up to establish a committee, that the DA has drawn up to establish a committee to consider the removal of a Chapter 9 institution. In terms of Section 194, we've modelled the rules on the rules adopted in terms of Section 89 for the removal of a president. I submit these draft rules in the hope that it can be of assistance to the Rules and Programming Committee when they meet to draw up rules to govern the process, considering the removal of the public protector. Now that is what is said to produce the Sobukwe clause. That is what is said to produce the vendetta, because Mr. Steenhuisen says, I hope it's of assistance to the committee when they consider rules regarding the removal of the public protector. But with respect, that was the only Chapter 9 institution that at that point was facing removal. So it is that which produced the urgency. And so it's hardly surprising that Mr. Steenhuisen made reference to it. And he makes the point, the DA believes the Parliament should move on the matter with an appropriate sense of urgency, which was the same point made on the previous page by the chair of the Portfolio Committee. With respect to suggest that that gives rise to an inference of an agenda, of a vendetta, or the Sobukwe clause, is just without any merit whatsoever. Particularly because we then know, this is on the 2nd of September, we then know that the rules are only eventually adopted on the 3rd of December 2019, after various lengthy debates, some of the debates you've been taken to already. So the suggestion that there is a vendetta by my client has simply not been shown. And ironically, having made these extraordinary allegations about a vendetta, the public protector then seeks to strike out the answers to the vendetta allegations. And you will see that, if I could just give you one example, you will see that if you look at page 695 of the papers. I think that is volume 7. I'm afraid mine is not neatly arranged in volumes. I can find it for you if you give me a moment.
That's volume 8. Volume 8.
I apologize. But you will see there at page 695, paragraph 17, the DA explains its motion. And it says at paragraph 17, the DA and its representatives are not acting in bad faith or with corrupt motives, that's the allegation, in seeking the removal of Ms. Mkhwebane. The DA and its representatives hold a genuine and well-founded view that she lacks the competence to perform the functions of her office and that she's guilty of misconduct. The DA is certainly not acting with an intention to destabilize the office of the public protector. On the contrary, it is acting out of concern to restore the effectiveness and integrity of the office. And then follows paragraphs 18 to 19, which are the paragraphs, among the paragraphs which the PP seeks to strike out. And what it says is, as appears from the charges, the basis of the DA's motion is not personal and it's not peculiar. The basis of the DA's motion is not personal, as Ms. Mkhwebane appears to believe, and it is not peculiar for the DA and its own assessment of Ms. Mkhwebane's conduct. It is premised inter alia on the very serious findings of the majority of 8 judges of the Constitutional Court. And then it cites that final judgment in the Saab case, and it goes on, paragraph 18, all the way through paragraph 19. In light of these findings of persistent concealment of the truth and multiple falsehoods on the part of Ms. Mkhwebane made by the highest court in the land, it's clear that Ms. Mkhwebane's continued occupancy of the office of the public protector is untenable. The public cannot be expected to have any confidence in the office of the public protector and cannot place its reliance for investigations and reports for so long as she is the incumbent. And she now seeks to strike that out, those paragraphs, with respect, and she does so on the basis that they are irrelevant and vexatious. With respect, she can't have it both ways. She comes to court and says, this is all a vendetta. It's all a smokescreen. The DA answers it with reference to a judgment of the Constitutional Court and explains its position. And she says that must be struck out as irrelevant and vexatious. And it happens again and again, the same with paragraph 22 of the answering affidavit. The same with the reference to Mr. Samuel, that annexure JS4, which is an affidavit. It's an affidavit, as was pointed out by the learned judge presiding, so it can't be hearsay, but it's said to be vexatious and irrelevant when it is one of the charges. So it's not clear how it can be vexatious and irrelevant. And then again, when in answer to the ATM, the DA draws attention to other cases, more recent cases, the CR17 case, which makes similar findings. So we submit with respect that not only is there no basis for an allegation of a vendetta, but in fact, the fact that it's been raised at all is irresponsible. The fact that it's been persisted with an attempt to strike out the answer to it is just without any merit whatsoever. And I'm going to come back to that when I come to the question of costs. Lastly, and in any event, even if there were ever a case that could be more clearly far away from a vendetta, it would be this one. This is a case where a final judgment issued by the highest court in the land has made the most serious findings imaginable about Ms. Mkhwebane. To suggest that the only basis for this is about busybodies and a vendetta is without any merit. So we say that the vendetta point should be rejected, and I will come back to it in the question of costs. Moving then to the third issue, and that's the conflict of interest issue. I'll be very brief on this, and it will develop a submission made by my learned friend, Mr. Breitenbach, but I do need to take it a little further. In the address by our learned friend, Mr. Mpofu, the argument about the conflict of interest relied squarely on paragraphs 118 and 119, or 119 in particular, of the EFF2 judgment. That is the judgment of the Deputy Chief Justice, Justice Zondo, which spoke about the fact that the issue had been prejudged. My learned friend, Mr. Breitenbach, points out that that was in the minority judgment, but it's actually worse than that. It's not just in the minority judgment, it is utterly inconsistent with the conclusion reached by the majority judgment and its order. Because you will recall that what the majority judgment did in paragraph 222 was it held that Parliament's failure to make rules was unconstitutional. It directed Parliament to do so. And it held that Parliament's failure to engage in a proper inquiry was unconstitutional and directed it to do so. And you'll see that when you have a chance to read paragraph 222, it makes clear, paragraph 222, for the failure by the National Assembly to determine the breach of the Constitution is inconsistent, and the National Assembly must comply with section 237 and fulfill the obligation. So that's what the majority says at paragraph 222. The minority at paragraph 118 criticizes that. And the minority says, if you begin at 116, and if I could read it to the court, one of the orders, this is the minority speaking, one of the orders made by the second judgment directs the National Assembly to initiate a process under section 89.1. The aim of the section 89.1 process is for the National Assembly to hold the president accountable. That means on the second judgment's approach, there must be a committee established to conduct a fact-finding inquiry or investigation into whether the president committed a serious violation of the Constitution. That committee would make a recommendation to the National Assembly. The court then says, the minority then says, there is another difficulty with the proposition. The difficulty is that the DA had already pronounced on this issue. That's in 117. It seems to me that it's not competent for the National Assembly to establish a committee that will do this when a large section of the National Assembly is represented by members of the DA, EFF, UDM, and COPE have passed judgment. 119. The applicants are not the only members who are disqualified from passing judgment on the issue. In other words, the minority judgment itself recognizes rightly that its conclusion at paragraphs 117 to 119 is utterly inconsistent with the order made by the majority. And yet it is those very passages which my learned friend relies on to try and create a basis for a contention of a conflict of interest. So the very foundation of his conflict of interest point rests on passages in a minority judgment, which the minority judgment itself recognizes are inconsistent with the order made by the majority. With great respect, those passages should carry no weight with this court whatsoever, because they are not the view of the majority of the court and are at odds with the view of the majority of the court. And really, I need say no more on conflict of interest, save to endorse the point that in the absence of citing individual members of Parliament, there could never be any serious suggestion that this court could make orders against those individuals. Then, in relation to the fourth part of this address, the question of the further flaws in the merits. We've dealt with many of the merits attacks in our heads. Our learned friend, Mr. Breitenbach, has done likewise. I just wish to draw attention to two issues, if I may. The first is the complaint about the judge. And our learned friend, Mr. Mpofu, with respect, conflated two separate questions. The first was, is there a lawful basis to appoint a judge? In other words, is there a power in law to do so? And the second is, does it violate the separation of powers principle? And those are two separate questions. The answer to the first question is obvious with respect. Of course there is. The rules themselves give rise to a power to appoint a judge, if that is deemed appropriate by the Speaker. So just we give the example of the Commissions Act. Our learned friend says in answer, but the Commissions Act confers that power. Well, just in this case, the rules confer the power. So as a matter of legality, vires, the rules confer the power to appoint the members of the panel and make clear that they may include a judge. Need not, but may. The real point he makes with respect is a different one, which is that there is a separation of powers breach. In other words, that's the Heath case or the Sarpel case, and that's the NSPCA cases, where those cases say, even though there is a power in law to appoint a judge, it is a breach of the separation of powers because this is an inherently impermissible thing for judges to do. We don't want judges sitting as an arm of the executive running the SIU, that's Heath. We don't want magistrates engaging in the sorts of inquiries, the sorts of activities around animal cruelty that was at issue in NSPCA. But with respect, the analogy is an entirely inapposite one, because the function of the sifting committee, and that's, of course, in the language of EFF2, what it is to do, the function of the sifting panel is to make sure that the complaint has legal merit. It wants to make sure that, legally speaking, this is a complaint with merit. Who better to do that than a judge? And how much more appropriate could it be than to have a judge when you are dealing not just with a member of an organ of state, but with a Chapter 9 institution? How utterly appropriate to say, we're not just going to pick 3 lawyers, but we may well pick a judge, because judges are seen to be independent and have the necessary independence. So with respect, we agree with our learned friend, Mr. Breitenbach, that this is not about whether the court agrees or disagrees. Rationality doesn't involve that. But my point I make is slightly different. It's one thing to say we want a judge in the arm of the executive running their SIU, that's Heath, and we can understand why that was impermissible. It's quite another to say we want a judge to perform one discrete inquiry in respect of one discrete person who's alleged to have been misconducted themselves, and where the only inquiry is one of law, and where it will not be determinative of that person's guilt or innocence. It seems to me, with great respect, it's eminently appropriate to have a judge, but to put it at its lowest, it certainly doesn't give rise to the separation of powers concerns. The only other case relied on in relation to the judge point was the Amabungani case, the case about Rika. But with respect, my learned friend has misread that case. Rika, the Amabungani case in which I appeared for the applicant, doesn't deal at all with the idea that it's inappropriate to have a judge performing these functions. It says exactly the opposite. What happened in Amabungani was that when surveillance orders are obtained against any of us, they have to be approved by the designated judge, because, of course, they are obtained ex parte and one never finds out about them. So the idea is that one has a judge who is a safeguard, an independent judge who is a safeguard. The complaint in Amabungani was not that it shouldn't be a judge. It was the opposite. It was that the judge shouldn't be appointed by the Minister of Justice, because then the judge was beholden to the executive. The judge should be appointed by the JSC or by Parliament, or organizations that are well regarded as appropriate to have a role in this. And the second complaint was that the judge shouldn't be appointed simply for a year at a time, on a renewable year at a time, because then it might be seen to be currying favor with the executive. None of that has any relevance to this case, because none of it goes to the question of whether a judge is appropriate or inappropriate, and no suggestion about a lack of independence has been pleaded in this case. So Amabungani, quite the contrary, is against my learned friend's argument, not in his favor. There's only one other merits ground I wish to deal with briefly, and that is the pending legal proceedings, the cross-examination issue. And we would simply say this. It seems to us that this is quintessentially an issue that this court need not get into in Part A for two reasons. The first is that this might well be a case. Sorry, let me explain what I say about what the issue is. There are two issues. The one is a contention which it doesn't appear is really made, that Ms. Mkhwebane should not have to appear herself and answer for herself, but should have a lawyer speak on her behalf. I don't really understand that that contention is made, and if it is made with respect, it is hopeless, because the idea of a Chapter 9 institution accounting directly to the committee is plainly appropriate. But the more subtle version of the point is the point raised by your lordship presiding this morning, which is, well, does Ms. Mkhwebane not need a lawyer in order to cross-examine witnesses if there are going to be witnesses? And that's a different point from the idea of whether she should speak for herself when she's asked questions. But with respect, there are two reasons that that latter point should not be determined here and is not a basis for the interim interdict. The first is that we don't even know yet whether there will be witnesses. You have seen the DA's charge sheet. It is largely based on decisions of the courts based on affidavits. It's eminently possible, and it's not for me to prejudge, it's not my job, but it's eminently possible that these are impeachment proceedings which would not involve the calling of witnesses and which would be decided on paper, as it were, the papers that are already before the court, before the committee, the affidavits that are already there. So it's eminently possible that there will be no need for cross-examination, because this is not the sort of case which turns on cross-examination. That's quite possible. But again, I don't want to determine that. But if that were the case, then this complaint could never be a basis for an interim interdict, because we don't even know whether the harm will come to fruition. But more importantly, it seems to us with respect that the rule in question is capable of two readings. And it's not obvious to us that, and I say this with the greatest of respect, that the speaker may have read it correctly if the speaker is contending that it doesn't allow cross-examination. Because what the rule says, and I've now lost the rule, if you'd give me one moment. If I could ask the court to go to the rule.
Page 140, 144. No?
Yes, 144 is where it begins, that's right.
And
then it's 140, it begins at 146 at the foot of the page.
Yes.
146 says the committee, 146.1 says the committee must conduct an inquiry and establish the veracity of the charges. And then 146.2, and I'll come back to this, says the committee must ensure that the inquiry is conducted in a reasonable and procedurally fair manner within a reasonable time. So there's a reference to procedural fairness. 147.3 then says the committee must afford the holder of a public office the right to be heard in his or her own defense and to be assisted by a legal practitioner or other expert of his or her own choice, provided that the legal practitioner or other expert may not participate in the committee. Now, it's not obvious what that means, at least in my submission. It might mean that the legal practitioner is not entitled to even cross-examine. Or it might mean that the legal practitioner is not entitled to speak on Ms. Mkhwebane's behalf in addressing the committee, as I've explained, but that the legal practitioner would be entitled to cross-examine if there are disputes of fact and if there are witnesses to be called. The rule is not clear on the point, or the rule is not dispositive of the point, and it needs to be understood in light of sub 2, which speaks about the need for the committee to ensure that the inquiry is conducted in a reasonable and procedurally fair manner. It seems eminently possible, interpreting this in light of the ordinary principles, that it may be possible to read these together to say that the committee retains the discretion to allow cross-examination by a lawyer if that is deemed appropriate. But the more important point, so the point I make is it may well be that in due course that is going to have to be an issue on which the committee seeks legal advice, and the committee will have to take legal advice, and if Ms. Mkhwebane wants her lawyer to cross-examine, she will have to ask for it, and the committee will rule. But the one thing that you cannot say with respect, for sure, is number one, that this rule precludes cross-examination, and two, more importantly, that cross-examination will even occur. So there is, because we don't know who's going to be called, if anyone.
That then would be a matter which the court in Part B will deal with in its interpretation of these rules.
Indeed.
Consistent with the rights of anybody who is affected by the outcome of an inquiry.
Your Lordship has the point with respect. Exactly. So, and I appreciate that diverges from the Speaker's argument, and the Speaker's argument might be right, but you will see that as the DA, both in our affidavit and in our heads, we've adopted a somewhat more narrow reading of it. And we certainly endorse, let me be clear, we endorse Mr. Breitenbach's submission that it's eminently rational and appropriate to say, if you are a Chapter 9 institution, you cannot come and hide behind your silk. You must answer for yourself. But that might be, and I just say might be, a separate question from whether you can still have your lawyer cross-examine. But I don't need to take it further for now, because it's not a matter that has to be decided now.
Mr. Badender, that raises the issue that I had raised earlier with Mr. Breitenbach, and that is the nature of the inquiry.
Yes.
And if the inquiry was to entail a fact-finding determination by this committee.
Yes.
And it's a committee of politicians with different interests, which are expressed very differently. They're not independent persons. And it's all the more important for whatever procedure is adopted in that inquiry to be fair and reasonable. And that's why the important issue of legal representation arises.
Yes.
That I suspect is where the applicant's concern arises.
But Judge Saldana, I couldn't agree more, but what's important is that we're now dealing with a frontal attack on the rules. But the rules are to be read as a whole, not one rule out of kilter with the rest. And what 129 AD2 says is that the committee must ensure that the inquiry is conducted in a reasonable and procedurally fair manner. So that very much supports the conclusion that you have articulated.
But we can't have a position where, well, and maybe that's what Part B will deal with. Yes. Is that they give an interpretation as to the rules, either consistent with the Constitution, and if it can't be, then they will sever. Indeed.
So they will determine what the rules. The court in Part B will determine what the rules mean, properly construed, and B, whether properly construed they are consistent with the Constitution, and if needs be, make an order in that regard. But none of that is the basis for an interim interdict pending Part B, more particularly in circumstances where we don't even know whether this is a case where evidence will have to be given and cross-examined. Could I give you an extreme example? There have been many extreme examples, but let me give you one which seems apposite to me. Suppose that the head of a Chapter 9 institution is found guilty of murder by a court, found guilty of murder, but for some reason is sentenced to a suspended imprisonment or is not sentenced to jail, so could notionally carry on, and refuses to vacate his or her office. That to me seems like a case where one is not going to need any evidence. The only debate is whether, in the circumstances of a finding of murder and the finding of the circumstances, that justifies gross misconduct or misconduct and should be removed. You don't need any evidence. It'll just be a matter of debate. Contrarily, if it's a matter that is never served before the courts, and it says Mr. X tried to bribe Mr. Y, who was the head of a public Chapter 9 institution, you might well need evidence, cross-examination, fact-finding. But everything depends on the circumstances. And so you cannot anticipate without more that there will always be cross-examination, and you certainly can't anticipate that the rule will be applied in a way that would breach fairness and reasonableness when the sub-rule preceding it requires fairness and reasonableness. So we submit with respect that the argument doesn't go anywhere.
Mr. Banner, can I then raise the ancillary issue? Is that assuming the applicant is not successful in the relief which it seeks before this court,
yes,
and between now and the 24th of November, the proceedings reach the committee stage.
Yes.
And at that stage, she seeks to assert a right to legal representation that allows for cross-examination of witnesses.
Yeah.
She'd be entitled to do that.
She'd be entitled to assert such a right. Whether the right is granted would depend on the ruling of the committee. And the committee would take legal advice, would hear from her lawyer, and would make a ruling. Absolutely.
And if not, she'd be entitled to seek relief from a court.
If the ruling went against her,
yes.
If she was not convicted, and if she was removed, then at the end of the day, of course, she would then be entitled to come and seek relief. She wouldn't be entitled to seek relief midstream, because, yes, of course, Again, we don't know what would happen. But if she was refused it and she was removed, she would of course be entitled to review on the basis that the proceedings were unlawful. That's absolutely right. Subject, of course, to the usual requirements of materiality and all the rest, but absolutely. Thank you, my lord. That leads to the fifth point, and the fifth point is the question of costs. We submit with respect that if the application is dismissed as it must be, and we submit, just to be clear, we submit that none of the grounds of attack have any merit, but I haven't dealt with them all because they've been dealt with very fully already. But we submit that if the application is to be dismissed, that costs should be awarded against the public protector. We too do not seek costs against the ATM. And we submit that for the reasons articulated, BioWatch does not apply here, and we haven't heard any argument on that. But we go further. We submit with respect that this is a matter in which punitive costs should be awarded. And we have addressed the question of punitive costs in our heads at paragraphs 67, it's at paragraph 67, and particularly in the footnotes there. And what we have done there is we have cited just some of the things that the public protector has now alleged. She says there's the DA's proven and undenied bias. She says the impugned rules were as a result of a hasty job by the DA and forced down the National Assembly's throat to have my removal from office expedited, possibly without even disclosing their origins and authorship by the DA. I don't know where this comes from. It's all in the correspondence. It says it's part of a targeted vendetta and the DA only seeks to undermine the independence of my office and the Constitution. This in circumstances where the Constitutional Court has said what it said about this incumbent and her behavior in the case which forms the primary charge. And then, of course, sometimes we know things are said in papers, and then with the benefit of hindsight, we read opposing papers and we realize we went too far. And the appropriate thing to do is apologize and withdraw, but at the very least, even if you're not going to apologize and withdraw, you don't repeat. But instead, we have what is said at paragraph 50, footnote 53, which is that the applicant's heads of argument repeat these, saying that in actual fact, what the 10th respondent attempts to do is meddle in individual cases or pending court cases under the guise of holding the public protector to account. The 10th respondent, a party which is clearly aggrieved by the findings of the public protector, instead of following legal authority established by the courts, now seeks to substitute the court processes with a parliamentary process. The courts prescribe a court process as opposed to what the DA seeks to do. With great respect, the DA wasn't a party in the Reserve Bank case. The Reserve Bank case is finished. It made the most serious findings imaginable. How any of this is justified is, with respect, not clear to us. And we submit that these are statements that shouldn't have been made, and they certainly shouldn't have been persisted in. And we would merely draw the attention of the court to the judgment of the Supreme Court of Appeal in National Director of Public Prosecutions versus Zuma. It's 2000, I don't think it's in the heads, it's 2009, volume 2 of the South African Law Reports, page 277, a decision of the SCA, and it is at paragraphs 81 to 82. And then...
And what year was... Two. Thank you.
And there, the SCA awarded punitive costs against Mr. Zuma for making irrelevant insults not based on suspicion and not on fact. And it added that punitive costs award was fully justified, especially since it's not the first occasion on which Mr. Zuma has insisted on including such irrelevant allegations. And of course, this is a litigant who knows about the duties of a litigant because she was the litigant in the Reserve Bank case who had punitive costs awarded against her. And we know that from that case and from the Black Sash case, and I'll just give you the reference, it's Black Sash Trust versus the Minister of Social Development, 2018, volume 12 of the Butterworth Constitutional Law Reports, page 1472, a decision of the Constitutional Court at paragraph 10. We know that where a public official, and this is a public official litigating with public money, where a public official engages in litigation in a manner that is in bad faith or grossly negligent, day bonus costs will follow. Now, we haven't asked for day bonus costs. What we've asked for is punitive costs, but we submit that at the very least, that is what should be granted in this case. Because really, these allegations should not have been made up front and they should not have been repeated. And to then compound them by seeking to strike out the DA's answer to these allegations, and then compound it further by seeking to prevent the DA's affidavit being received in circumstances where it was filed in February of this year and answered without demur in March of this year, we submit really with great respect, this is not an appropriate way for litigation to be conducted by a Chapter 9 institution. And we would lastly just commend to you the judgment, the recent judgment of the full bench in the North Gauteng High Court in One South Africa Movement versus the President. The neutral citation is 2020 ZAGP PHC 249, and we'll let your registrar have a copy. It's 1 July 2020. And the court said there at paragraphs 209 to 211 that our system of adversarial litigation occurs within a society in which freedom of expression is a fundamental part of the constitutional order. The consequence is often what is described as, quote, no holds barred litigation, which for some may translate to mean there should be no boundaries to the manner in which parties litigate. This cannot be so and cannot be consistent with the values of human dignity and respect that the Constitution seeks to advance. In this application, there were many examples of such boundless and unjustified applications launched. They range from accusations of racism to wanton disregard. The court goes on and on. Now, there the court didn't award costs, but that's only because both parties were guilty of the same thing. So it wasn't going to award costs to either party. Here we've got the reverse. We've got one party who's engaged in these allegations. They are not appropriate. They are not permissible. They've been persisted in, and we would ask for a special costs order in this regard. Judge, my Lord, unless there's anything else, those are our submissions.
Good. Thank you, Judge Stein. Judge Sumela, there's something to raise with you.
Thank you.
Mr. Butler, can you hear me?
I can. Thank you, Judge.
Right. I just want to find out for... Sorry. Is it fine? Seem to have a problem. You can go? Okay. I just want to find out your comments regarding especially Part A. Whether do you agree with the proposition that the Speaker's action was and is in accordance with the rules of Parliament that were unanimously adopted, and therefore if the applicant is allowed the relief that she's seeking, that would be to disrupt or to interdict Parliament and consequently breaching the separation of rules. And as such, therefore, the applicant failed in addressing fully, amongst other things, the question of irreparable harm, the balance of convenience, and whether then there is no suitable alternative remedy to her case. Thank you.
Thank you, my Lord. In short, the answer is absolutely yes. We endorse that proposition in its entirety, and we would, it seems to us that the language that is appropriate is paragraph 26 of Outer, where the court says, Constitutional Court says, a court also must be alive to and carefully consider whether the temporary restraining order would unduly trespass upon the sole terrain of other branches of government, even before the final determination of review grounds. A court must be astute not to stop dead the exercise of executive or legislative power before the exercise has successfully and finally been impugned on review. This approach accords well with the comity the courts owe to both other branches of government, provided they act lawfully. So we submit with respect, that is exactly the point that you have made to me correctly. If this court were to grant Part A, it would be stopping dead the exercise of legislative power, legislative oversight, obviously, by Parliament, before the exercise has been successfully and finally impugned on review. And that is exactly what the court says in Outer, that a court is not permitted to do.
So you're saying, therefore, that his court then is bound by cases like Outa, Mushalocha, and Jiba, amongst other cases to follow.
Indeed. We endorse all of those submissions already advanced, and we say that they have great force, and the court is very much bound by them.
Okay, thank you very much.
Thank you, Mr. Butler.
Thank you, my lords and my ladies.
Thank you, Mr. Butler. Good. We at 5:45, and now we deal with the reply, Mr. Mpofu and Mr. Sikakane. Mr. Mpofu, are you with us?
Yes, I am, my lord. Can you hear me?
We can hear you. We can't see you.
Okay.
My lord, can you hear me?
We can see Mr. Sikakane. We can hear him also.
My lord, can I make things easier right at the outset? Yes. If you're worried about time, I will not be doing any reply.
Okay, good. Thank you, Mr. Sikakane.
Thank you.
Mr. Mpofu, floor is yours.
Thank you very much. Can you hear and see me now, my lord?
Yes, we can hear and see you. Thank you.
Thank you. Right. My lord, I will, because of some of the issues that have been said, basically, I'm just going to deal with some of the defenses argued or raised by Mr. Breitenbach and some of the defenses by Mr. Badlander and some of the defenses that were raised by the court and understandably embraced by them. For example, this issue about temporary incapacity and the involvement of the bench and so on. And then I'll also raise some of the issues raised by the court to them, such as the issue of the legal representation. But before I do that, I think it's very important to explain to this court, hopefully with some effect, what this case is not about. Because I think throughout all these comments, everybody has just been answering the wrong case. This case is not so much about the particular facts and circumstances that surround a certain person called Ms. Mkhwebane and a certain motion by somebody called Ms. Mazoni, and so on and so on. That is part of the attack insofar as what we call the implementation, and that relates particularly to the implementation by the speaker. Yes. But this case is about a constitutional attack on the rules. And if that point is lost, then we might just as well all go home right now. Because the issue is a very simple one. Do the rules at a prima facie level pass constitutional muster? Yes or no? And I'm putting aside for now questions of whether there's an overall taint on the rules or whether it's severable and so on. I'll come to that, the issues that the court debated with Mr. Badlander, I think. And that's why I'm saying, let's just again, I said this yesterday, I know, but let's assume for a minute that the rules have all those taints that cannot be resolved, or at least at a prima facie level, that look like they are fatal to the rules. Now, if that is so, then comes the issues, the other issues which will inform this court about the granting or non-granting of an interim interdict. And I'm going to come to that just now, because that also seems, especially from what Mr. Badlander said, I'm actually going to start with the other requirements, just to show that, because yesterday we started with the prima facie right for obvious reasons, because this is a double-barreled attack of a declarator and a review in Part B. But just because maybe time, the time allocated to some of the other areas was not equal to that, then comes this unfounded accusation that we did not address the other requirements. To be sure, the other requirements we addressed, and the questions were teased out by Judge Samela correctly in respect of some of those issues. And those issues are addressed at length. I will show, for example, with irreparable harm, there are 5 or 6 topics that are covered in the founding affidavit in respect of that alone. And so the question of the threat of suspension, there's the issue of the destabilization of the office, and so on and so on. And yet we are told there's only one issue, a single issue about the Busasa conflict and so on, when the matters are spelled out in detail in the founding affidavit. Let me start by this, my lord, to paraphrase some of the issues around the requirements of interdict that were raised by Justice Samela and by us yesterday. I'll refer your lordship to the latest case out of the box in regard to this is the case that my learned friend Mr. Breitenbach referred to, which is EFF versus Godan, public protector and another. I don't have the law report citation, but I think Mr. Breitenbach did mention it. But my citation is it's a Constitutional Court decision. It's 2020 ZACC 10 of 29 May 2020. That case, you will recall, dealt with an interim interdict in the same kind of situation, except that the public protector was on the other side of the interdict, so to speak. The interdict, she was the respondent. And the court there said that, among other things, that despite the outer test, which I'm going to explain again, does not apply here at all, that an interdict of the sort that was sought, where the public protector said, no, you can't give such an interdict to Mr. Godan because of outer, because you'll be interfering with my constitutional powers and all the things that have been said today. But the Constitutional Court said, no, we will give such an interdict, despite all the so-called separation of powers harm, which, at least in that case, nobody said outer does not apply, unlike here. And one of the issues that were raised by the Constitutional Court in the judgment of Hampepe J, I will read at paragraph 24 of that judgment, my lord. She says some of the things that I raised yesterday. In analyzing the facts and applying the requirements of an interim interdict, the High Court found that the various grounds of review advanced by Mr. Godan were sufficient to constitute a prima facie right to the relief sought. So that's the relevance of the prima facie right and the peeking into the review, which I think everyone accepts is competent. Then, in respect of the other requirements, the court said the harm to Mr. Gordhan lay in the fact that he was to be disciplined by the president, appear before the Parliamentary Ethics Committee, and be criminally investigated by the Commissioner of Police, all of which had serious consequences for him. Let me just pause there. I tried to explain yesterday this nature of harm, which is not necessarily outcome-based. And that's why this thing about whether she will indeed be removed and what have you, the numbers of the DA is taken out of context. The harm, the real harm is not so much, let's assume she's going to be acquitted to illustrate this point. That has absolutely nothing to do with the kind of harm that was envisaged by the Constitutional Court in this passage, which is that the mere process of being subjected to these things, appearing before this one, being disciplined by this one, and so on, is obviously has serious consequences to a person. I don't think I have to spell out, and I made an example yesterday, that the fact that you are going to be acquitted does not mean you must put up with an unlawful arrest and malicious prosecution and just go on because you just know that, oh, fine, anyway, I'm innocent. At the end, I'll be acquitted. It's obvious that why the law protects you from even the arrest and all sorts of things and detention and what have you. The court went on to say the High Court highlighted that the SARS report maligned him as being untruthful and a spy and would impact his political career and his personal circumstances. So again, the kinds of things that get said about you in the process, not necessarily at the end, says the harm would be irreparable if the interdict was not granted. And thus the harm to the public protector and now you must say to the speaker, in awaiting the outcome of the review decision, weighed against the harm that would befall Mr. Gordhan if the interdict was not granted, resulted in the balance of convenience favoring the granting of the interdict. It was also found that there was no satisfactory alternative remedy available to Mr. Gordhan in view of the binding nature of the remedial action. I'll come to the question of, obviously that last sentence doesn't apply here, so I'll come to the question of alternative remedy separately. I'm simply now addressing the question of irreparable harm. Then at paragraph 67 of the same judgment, and this is the question really that, again, I was trying to ask yesterday. What is the speaker? I mean, we understand the overzealousness of the DA in pursuing this matter, no matter what, in saying, no, we don't care, we don't want even to wait for the 24th of November. You know, we must all, you know, get the road, the whole process, you know, underway like yesterday. That's fine. That's that's part of what they have to do in respect of their political mandate and so on. Fine. But what is the speaker going to lose if in the interest of fairness, the constitutionality of these rules is determined, especially now that we have an expedited process where that will be done in Part B, as opposed to all the obvious harm that will befall a person in the position of the public protector, coupled with the harm that will come to the institution, coupled with the harm that may come to employees of the public protector's office, coupled with the harm that may befall the public in the fight against corruption, and so on and so on.
Sorry, Mr. Mpofu, I don't follow that. Sorry, I don't follow the harm to the employees and the fight against corruption. Hold on, because I understand that there is a deputy public protector and there's other staff who can continue with the work.
Yes, No, of course there is, but anybody who has ever been in an organization where there's a leader of that organization, whether it's the president or the CEO or that kind of person in an organization, the removal of that person, the mere fact that yes, there'll be a deputy president or a deputy chair of the board or a deputy CEO cannot necessarily completely answer the destabilization that follows the removal of the real driver, of the pilot of the plane, so to speak, even though there might be another pilot. But the point of the matter is that let's even assume that the harm is not or that particular aspect of the harm is not there. What about the others compared to what? Right? Now, because in the weighing process, you must say, oh, well, what about this? Well, okay, the destabilization, yes, the embarrassment, yes, the dark cloud, yes, and that, but versus this and that and that. But what is that? As far as the speaker is concerned, it's zero, it's nothing. This is what the Constitutional Court had to say at paragraph 66, as I say, when the roles were reversed. There is no foreseeable irreparable harm to the public that the public protector would suffer. In other words, if Mr. Gordhan's harm was given effect to, right? The interim interdict would not thwart her constitutional mandate, and it would not offend any of her powers and functions as set out in the Constitution. Ditto the speaker here. There's no harm that she will suffer. The investigation into SARS has been completed and the SARS report has been published. There are no findings by the High Court in this order that would be considered causing irreparable harm to the Office of the Public Protector, nor would the effects of the findings cause irreparable harm. So that's what the finding is. Then here's the rub. On the other hand, Mr. Gordhan, and in this case, as I say, the roles are reversed, may suffer discernible irreparable harm and preclude, and prejudice should the interim interdict not be granted. The reasonable apprehension of irreparable harm to Mr. Gordhan lies in the fact that if the remedial action is not suspended, he would be disciplined by the president. Again, not necessarily convicted, but disciplined, just the process. Appear before the Parliamentary Ethics Committee. Well, we know what will happen here. Ms. Kwabane will have to appear before all these things, the independent panel, there's this one and that one. And be criminally investigated by the Commissioner of Police. That may or may not happen, even though some of the charges border on that. And then it says, all of which could have serious consequences for him. According to the High Court, the SARS report maligned him as being untruthful and a spy. Well, what can I say? It is therefore a reasonable apprehension that the remedial action contained in the SARS report would impact his political career. Well, not political career in this case, but vocational career, and his personal circumstances. It should be self-evident that a person who's a family person and who will be subjected to all these things, including a suspension. These fears are not misplaced, and the full effect of these potential consequences should be held in abeyance until the review application is completed. If I can read that again. These fears are not misplaced, and the full effect of these potential consequences should be held in abeyance until the review application is completed. That is what is dealt with here, which we dealt with ad nauseum yesterday in relation to the potential harm and the actual harm. Here, there wasn't even an issue of this vulnerability to suspension, which aggravates the potential harms in our particular case. Right, and then as far as the question that was raised by the court is concerned, but I see that today, at least it looked like there was an understanding on it between the court and Mr. Breitenbach. But yesterday, I thought that there was an issue about this, so I must just emphasize it. At paragraph 42 of this judgment, this is what the court said. And this is now the relationship, again, this should not be really a big issue. The relationship between Part A and Part B, that you can't have a Chinese wall between these two things. And the court, I think today, referred to it with respect appropriately as delicate balance, which is true. But insofar as there was a debate about it yesterday, I think I must emphasize this point. In addition, before the court may grant an interim interdict, it must be satisfied that the applicant for an interdict has good prospects of success in the main review. Let me pause there again. This is why the emphasis was put on the 10 grounds and so on, and the unconstitutionality issue, to show that there are good prospects of success in the main application. And that, my lord, with the greatest respect, at this stage does not have to go any further than a prima facie apprehension. I'm putting aside the things about clearest of cases. I said yesterday that even if you use the clearest of cases test, that is surpassed. Let's give an example why in the issue that your lordship debated with my learned friend about the legal representation. Nobody has given any tangible reason why legal representation must be denied such a fundamental right, except to say that the person is accounting personally. That's clearly not an answer, because everyone who gets legal representation is also accounting personally. Mr. Breitenbach quite correctly used the American example, which I used as well yesterday, of the Trump impeachment. And there we saw the other extreme. He's quite right, where there were, for weeks on end, there was this impeachment process, and Mr. Trump, I don't even think ever even entered that room. It was just the lawyers. That's not what we're asking for. But it does. The other extreme is equally bad, of actually having the person not represented by any lawyer, or by what I called yesterday a mummified lawyer who does not speak, which clearly is not a fulfillment of the right to legal representation. So, and again, we accept unreservedly, my lord, that it is not for this court to say, no, the rule must say you must have 2 lawyers, or 3, or 8, or whatever. That would be interference. That's not what we're asking for. What we're asking for is a very simple thing, for this court to declare whether, that's the word that is being missing there, whether a rule that denies you legal representation, as this one does, is in conformity with our constitutional dispensation, yes or no. That's it. That's all the court has to determine. Not prescribe to the legislature how they must resolve the problem. Whether, not how, whether such a rule conforms or does not conform with procedural irrationality and all the things we have said. Full stop. That's the end of it. So I'm told there might be a problem with sound. My lord, can you still hear me? Hello?
We can hear you, darling.
Okay, I'm wondering if okay, thanks, Stephen. Justice Saldana? Okay, I think I've lost, I probably have everyone else except for the court here. Okay, I'll try. Stephen?
Hi, darling.
Yeah, no, that's fine. I wanted to know if who got the hotline to the other side.
I can hear you.
Hello?
I can hear you.
Yes, Justice Skakanes, that's fine. But I think I prefer the other three. The technical person on the other side.
It's not us.
No, let me see. It's on the, okay, yeah, those who can hear me, it looks like it's on the side of the judges. From the box. Yeah, I want from the box. I hope we didn't lose them on this point, because this is very important. I don't know because I will lost them or not, I'm going to repeat. That's fine. With nothing to hide. I know, sometimes. No, at the pants.
Yes, from the court side. No, welcome. Are you able to talk to her? Okay, thank you so much, Pio. Thank you. Okay. The judges are trying to log in again.
But who's the host? At the host.
The host.
Let's see.
Sorry, just want to mute, just in case.
Yes.
Hello? Can anyone hear me?
Yeah, darling, we can hear you.
Okay. Looks like, has anyone got any, can anyone hear the charges?
Hi, everyone. Sorry, I've just spoken to the registrar, Stephen. Can you hear me? They've been thrown out of the
Are you
session. They've been thrown out of the session. So, is there any way any of you know how to re-invite them?
I thought they were the hosts.
They are, but they can't seem to get back in, and perhaps they have internet, but maybe I've tried to tell them to re-log into their own invitation.
Yeah, they only.
Yes, they can use the link.
The same link.
Yes.
But it doesn't seem to work. But I'll keep on trying to help the registrar. I've just spoken to her. She's. If anyone else has a idea.
Well, we could just create a new meeting, and we could email it to everyone. But then we've all got to log back in. I'm worried we're going to lose people.
Yeah.
We'll lose someone else. Yeah.
So let me just quickly phone her again and see if they can't be readmitted by the way we did this morning.
Linda.
Okay. So just hold on.
Thanks, Selzon.
Okay.
You know what? I think the meeting thing expired.
No, Zoom expires. This doesn't. I don't think this one.
My client expires.
So what's going on? If Pela abakhona
Dali and everyone. Dali, Andrew, Muzi, Nazreen.
Okay, I can hear you, Stephen.
My attorney's been speaking to the court. It sounds like they've got a difficulty in getting back onto Teams at all, never mind the link. So I think what we should do to avoid us logging off is, can I get my attorney to send us all a Zoom link? And that way we can try and log into Zoom before we all log out of Teams. And if that works, we can then shut down Teams. Should we try that?
Yes.
I have no problem with it.
That can work, Stephen. No problem.
Okay.
Isn't there a time limit, Stephen?
Yeah.
On what's it? On Zoom, don't you have that interruption? I've had more problems with Zoom than Teams.
No, I appreciate that. Well, I've got an unlimited Zoom account which we can use. It won't have an interruption.
Oh, fine. We'll use it, yeah.
Okay. All right. I'll set it up now.
Thank you. Okay. So you're saying we must not log out first?
Don't log out. Just stay on.
Yeah. Okay. Might be.
Okay, everyone, I'm going to email it off to the email that was sent this morning, and then I'll send it separately to the judges.
Stephen?
Yes.
Allow the judge to record the session as well.
Well, I'm not sure how much longer we'll even be, but we can try. I can record it and provide it if needs be. Let's try and get online.
Stephen, I've spoken to the registrar and they're looking for the invite. So
it's on its way. Don, will you forward it to them?
Well, okay, cool.
I don't have their email addresses.
It's fine. It's fine.
Okay, I've sent it.
Good.
Stephen, it's Andrew here.
Yes.
May I forward this to the parliamentary people to log on and to try and stream again?
Sure.
Stephen, you might have to deactivate your waiting room.
Yeah, I'm not sure how to do that. Otherwise, I'll just admit everyone.
Okay.
Do you think we can safely log off from Teams or not?
Just wait till the judges are on, and then you can log off. Is he joining, Stephen? He's on. Can you just check Dali's mic? No, it's not.
you.